one, wake up, really gonna rise with the sun. Step two, get some good, some food in you. Step three, think real hard about what you wanna be. Step four, everybody just do your thing.
Wake up, today's gonna be a good day. 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 Yo. Set your affirmations, aspirations. I got shit to do, the aftermath of preparation. Good food, good mood, blood in circulation. One step at a time, yeah, that's how you make it. Set a goal you control and the steps you take them. I try to pick one thought, have some concentration. And if I make a mistake, it's called education. I try to do this every day, call it replication. Wake up, today's gonna be a good day. 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 So life ain't easy, yo, I think there's a reason though. Ups and downs, just like every different season, yo. Sometimes I'm high, other times I'm barely breathing, though. I always gotta fight and hide from the demons, yo. Negative thoughts are poison, they rot. Head full of flies, so here come the clouds. They'll never stop unless I can swap all the bad for the good in my head when I'm lost. Yeah, so I'ma fake it till I make it. Positive thoughts are overtaken, I got patience. One day at a time is how you operate a cadence. A flow, you grow, you show yourself a foundation. Stay away from all the shit that causes temptation. I know that I like to do it cause it's sensation. I live my life in my head like a narration. Don't expect greatness, do my best, man, I'll take it. Wake up, today's gonna be a good day. 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 Wake up, today's gonna be a good day.
Wake up, really gonna rise with the sun. Step two, get some good, some food in you. Step three, think real hard about what you wanna be. Step four, everybody just do your thing.
Of course, there is problems in that we have lost 2 additional jurors today due to a positive test of COVID. So we had lost 1 juror earlier because of some sort of family emergency. And then we lost 2 more jurors today because of a positive COVID test, which leaves us with 3 alternate jurors. Now, if we don't have 12 jurors by the end of this, then we get to do this all over again. Mistrial by manifest necessity. Fun and exciting. We no longer have the sufficient number of jurors. We tried to get enough. We ran out. It's no one's fault. Redo, right? It's not an error that's incurred by the states. It's an error incurred by the world. So mistrial by manifest necessity. So we may wind up doing this all over again, depending on how many more jurors we lose along the way. If that happens, I will be sad. But that is definitely a possibility for sure. So yes. Also, we learned today that the fine people of OnStar, GM, have suddenly found data relating to the car in question. The state apparently at some point, as part of its investigation process, sent a subpoena to GM. OnStar said, hey, give us the OnStar data. And GM said, we don't have the OnStar data. We don't have it. Can't make it. We don't have it. Well, apparently, according to the state's representations today, the fine people of OnStar apparently have been watching this trial and were like, wait a second, they don't have the OnStar data. Let's take a look. And presto, bingo, the data is now available. And it just was produced. So all someone had to do was press a button and there it was. Which makes you wonder a little bit about what happened before, to be quite honest. Because like when we sent you the subpoena and be like, give us the OnStar data, and you said we don't have the OnStar data. My question is, so like what changed? Who lied? Who did it bad at OnStar? Now it seems that the defense doesn't have any particular objection to this evidence coming in at this time, because it is, at least as they've represented so far, consistent with all the time frame data they had before. So the defense is not arguing some sort of unfair surprise, which would be obvious an objection, right? It's like this is data we didn't have to prepare for, unfair surprise, right? But they aren't making that objection, or at least they haven't made that objection yet. It seems like the defense wants it because they feel like there are portions of the data that are helpful to their case. Fine. So apparently they are going to have someone from GM OnStar on Wednesday who is the records custodian. Maybe he can be asked, hey, you know how you said earlier you didn't have the records? What up with that, homie? Because that would be my question as the judge, right? I want to know the answer to that question, right? I don't care if the attorneys want to know. I want to know. Because you are now potentially in violation of the court process, and I might want to thump your skull. But we'll see what's going to happen in terms of all that. So, yeah. So we'll see what's going to happen in terms of all that. Now, it doesn't seem like there's any constitutional violation here. The state can only give what evidence it has. The state is required to turn over any incriminating evidence under Brady versus Maryland. If they don't have it, they can't turn it over. GM OnStar is not a governmental agency, so they are not imputed like it would be if it were the police department, right? So if the police department said, if the situation was, the prosecutor says, well, we didn't have the DNA evidence. We subpoenaed the state crime lab, and they said we don't have the DNA evidence. And then suddenly the state crime lab's like, yes, we do. We have it, right? You can't do that because the prosecution is bound to turn over evidence of the state, which includes the state crime lab. So not only information in their own possession, but information in possession of the state, period. So the prosecutor being like, I didn't know, actually doesn't work. There was a U.S. Supreme Court case on that point, right? So if that were the scenario, we'd still be talking about Brady, although strictly not Brady because there was a subsequent case that held it applicable, but same idea. But because, of course, OnStar GM is not a governmental agency, you don't have the imputation that you would have. So it's not a violation in that sense, but the defense obviously could still say unfair surprise because we didn't have it. But if they don't want to object to it, then I guess everyone's happy. So, fine. I bet OnStar updates their privacy policies. Their privacy policies has zero to do with this. You can't write a privacy policy around this, right? If you have the data, you have to give the data. That's the nature of a subpoena, right? You have to comply with governmental state. You have to comply with orders. So OnStar can revise their privacy policies all they want. I don't know how it could possibly matter one way or another, to be quite honest, in any event. Whatever their privacy policy did say or would say has very little to do with anything in this analysis. So, anyways, so that is where we were sitting on that. So the witnesses started with Ryan Kelly from SLED just for the limited purpose of saying how he collected DNA samples. Then we heard from Rachel Wynn, DNA forensic expert, who testified that various shell casings that were found had DNA from various people in the Murdaugh family. Now, I don't know what the significance of this is because at least it doesn't seem that these shell casings have been tied to the murder. There's a lot of firearms discharged on this property, including the firearm that was used in the murder, if it was the firearm used in the murder, because we don't have that either. But this firearm, if it was the firearm used, had been used a lot on the property for hunting. And so the shell casings that are found near the scene of the murder don't necessarily mean they're from the time of the murder, unless there was some sort of information that passed my attention, which is possible because it's been difficult at times to pay attention to this in full because it's really, really dull. In terms of the way the evidence is presented, it's been problematic. So anyways, there was a lot of DNA evidence. They also talked about this presumptive DNA testing and the blood testing, or not blood, because although it tested presumptively positive for blood, it did not test confirmed positive for blood, although there was DNA. So DNA, but not blood, or DNA, but we're not sure if it's blood, from the shirt. Now, from my knowledge of the preliminary hearings, it was my understanding that in order to detect whether it's blood or not, you need at least 4 micrograms. But for DNA, you only need 1 nanogram. So presumably, it would be somewhere between 1 nanogram and 4 micrograms. But 1 nanogram and or 4 micrograms is not very much. A microgram is a millionth of a gram. 4 millionths of a gram. A gram is roughly a paperclip. Is roughly a gram. So take a paperclip and divide it into million segments and get 4 of them, and that's how much we're talking about. So it's not much. So when you say that the wife's DNA was found on the shirt, wow, tell me another tale, right? If the wife was anywhere, even remotely close to the shirt at any time, breathing in the same room, there's probably 4 micrograms of her DNA on the shirt. You know, because when you breathe out water that might contain DNA and skin flakes and everything. So it's like when they say there was some DNA from these people, I'm like, wow, tell me another story. The blue raincoat of Destiny had no presumptive positive for blood anywhere on the coat. So the coat, which the state's theory is the guns were wrapped into in the immediate aftermath of the very, very bloody murders, there is no blood on the coat. 71 spots they tested for blood and no blood on the coat. When they found cartridge casings to test for DNA, they soaked all 6 of them in the same solution at the same time, which seems like a questionable practice to me, because now you can't determine which of the 6 had the DNA on it. You would be able to conclude it came from one of them, but which, you don't know. And you don't know if it was only on one of them or all of them or some of them, and that might be valuable information, but apparently that's not how we test things. The Ford F-250 pulse truck was also tested, no DNA found. So that seemed like a whole lot of stupid. Sarah Zapata, DNA analyst, testified to more DNA stuff and DNA profiles. And this is the one where she had all sorts of weird analogies to explain things. And the seesaw and grandma's cookie recipe somehow entered the mix. Grandma's cookie recipe, which you know has 2 cups of flours and something, DNA, question mark. The analogy left a little bit to be desired. They talked about the fact that, like, Alex and Murdaugh contributed blood to various things that were found, like the shotgun that Murdaugh had with him the night of the murders. Not the murder weapon, but the night of the murder. Of course, Alex Murdaugh's DNA is on it. He was holding it. And again, if you found Maggie's DNA on it, she lived there. So again, I mean, sure, but it's not the murder weapon, right? If it was the murder weapon, this would be a lot more interesting. If you had the murder weapon and you said all the DNA I can detect from this was some combination of Alex, Paul, and Maggie, and no one else, that would be pretty informative, right? Because if it were the murder weapon and the only people's DNA you found on it were Alex, Paul, and Maggie's, then the logical conclusion would be only those people touched it. Now, of course, it's possible that someone else touched it with gloves, but now you are, at least you are a lot closer to saying, these, and again, because you're talking about such minute numbers, that this person, the real killer, wouldn't get sweat on it anywhere, whatever, or touch it or whatever, that seems a little bit more improbable. So if you had the murder weapons and you said, I found only some combination of Alex, Paul, and Maggie's DNA, that would be a lot more helpful. I found them on guns unrelated to the murders, not particularly helpful. Because you don't know, well, they weren't used in the murders. He got it from his house for his own protection when the police were taking 20 minutes to show up because he lived in the middle of nowhere and he wanted to protect himself. So he says, and presumption of innocence is him. So yes, their DNA is on the gun. Tell me a different story, right? It doesn't really make any sense. Then the one that I thought was interesting was DNA found under Maggie's fingernails. We found unknown person DNA under her fingernails. It seems that she went to have her nails done earlier that day, which, presumably means that the nails were cleaned. And so you would expect them to have DNA from only people that she would have come in contact with during or after the nail salon. They tested the DNA under her fingernails against something like 15 different people. It was a long list. The only one who came close was this guy, Claude Rowe. And then who was the I joined the SEALs team to kill the Black Panthers guy with the sunflower seeds. But even him was a very low match. It was 11-1 probability. Now, at least from my memory, it was unclear which way it was 11-1, right? It wasn't clear to me which way it was 11-1. And I think that the person testifying might have actually said both, which confused it. So you have two possible universes, right? Is it Claude's DNA or is it someone else's DNA? So these are the things you're comparing on, the probabilities, Claude's DNA and someone else's DNA. So one of them is 11 times more probable than the other one, but it wasn't 100% sure which one. Because I think that, at least from my way of hearing the testimony, and she might have misspoken, but the way I heard it, I think she said it both ways around. Regardless of which way it is around, though, 11-1 is not considered a high probability match. Not in these kinds of numbers, because in these kinds of numbers, we were dealing with numbers that are so huge. They're numbers that I haven't heard in a while, right? We're talking about quadrillions, quintillions, octillions, and I think we got to sextillion at one point, which is 16 times 3 zeros. I think we got to sextillion at one point. So when you're talking about comparative probabilities of 1 to, a sextillion on the one hand, and 11-1 on the other hand, 11-1 is not very compelling. So it might have been the groundskeeper, maybe, but it was an unknown match, and they weren't able to get to any level of confidence. So this seemed like a pretty interesting thing. Why they say CB Rowe was 11-1 and not quintillion percent? Presumably because they're not making things up. And that was as confident as they were able to be. The reason it seems that was as confident as they're able to be is because they only found 3 unknown alleles. Alleles are like a marker in DNA. And so the more alleles that you are comparing, the more unique you have. So random people share alleles. So if you take any two people, because people share DNA, right? They share segments of DNA, right? You will find commonalities in alleles. It's only when you have so many alleles that you can get to higher and higher levels of confidence. So apparently with 3 alleles, you can get down to 11-1, which, there was been 11 people in the courtroom at that time by quite a bit. So it could be this guy, or it could be any one of 7 different people in the courtroom as we're talking. That kind of thing. So it could be this guy, or it could be, well, there's more than 11 people on the jury. So it could be this guy, or it could be one of the jurors, right? So not a great match. We also learned apparently that when you're doing a presumptive test for blood, other non-blood things can test positive for blood. What are those things? Well, apparently cauliflower. Cauliflower is one of the things. It could be blood, or it could be cauliflower. We're not sure which. Could go either way. Blood, cauliflower. This, of course, assumes it's human blood at all. At this point, we're just trying to determine blood, period. Blood of some variety. Could be in animals, or it could be cauliflower. Or horseradish. Horseradish was also there. Horseradish or cauliflower. So we have learned a new way into a vampire's heart. If you have a vampire, just make them a dish of cauliflower. Really, really works great, apparently. So, okay. Fine. So there were lots of problems with the DNA test, because I don't think they really proved anything, to be honest. They found the family's DNA on the guns that were in the family's home. Wow. We finally concluded with Dr. Ellen Reamer, who has done 5,500 autopsies in her career and also really loves her job a lot. She has a very jovial, happy, excited style of talking about the murders. She likes talking about the murders. She would really like to talk to you about the dead bodies and the murders. It makes her really, really happy and excited, and it's a little much. Also, somehow simultaneously, she's also very dry to listen to. I'm not sure how both these things are possible at the same time, but she found a way. She found a way to simultaneously come off as really interested, really excited, really happy, kind of inappropriately so, and also be really boring. Also, a little bit patronizing at times, where I felt like I was being talked down to. And she was somewhat vivid in her descriptions, describing how the shotgun blast killed him. Apparently, the first shotgun blast he would have survived, but the second shotgun blast went through his skull, and his brains came out and had to be collected separately in a bucket. Apparently, and I did not know this, apparently, being shot in the head by a shotgun to the point the brains come out of the skull would be instantly fatal. Wow. I know. This is a revelation. I know. Apparently this would instantly kill a person. Okay. So, yeah. They said there were no defensive wounds, like their hands weren't up at the time. So, whatever. The toxology report, Paul only had caffeine in his system. And then they went through some detail about the order of the shots. Reamer also said the next to last and final shots came from different directions, which is an interesting thing. And we had no cross-examination yet. Also, the manner of death was homicide. So, glad we cleared that up. So, I find the state's overall evidence continuing to be not very helpful in trying to determine who the murderers are. It just feels like a lot of dots scattered, and to my mind, I don't see a pattern. I just see a lot of dots scattered around, and that don't look like anything. They don't seem to be trending towards anything. It looks like random noise to me. It doesn't seem to be driving anywhere. Aggie also had only caffeine in her system, for whatever it's worth. So, all that stuff. So I don't really find this very helpful. Paul's DNA was found on the shed in which he was killed. His DNA was found on the knob of the door that goes into the shed in which he was killed. So Paul was present at the location in which he was killed. That was helpful information. So I don't really understand any of this really from the state's case. And I continue to think the state's case is basically non-existent. That being the case, however, my perception, of course, is not the jury's perception. And the jury is able to see a lot more evidence than I am, and you and I are together. So, what it all means is open to some question. I thought we'd also go again and just look at this chart that I did earlier today at the start of my stream today. So for those of you who saw my stream earlier, this will be familiar. But I thought we could take another look at it because it was kind of helpful and informative. All right, so this is a timeline of the murders that someone on Twitter put together. My belief is that where it says duration, time, seconds, activity per evidence and data collected, my belief is that those fields are factual. The left-handmost column theory and the right-handmost column details on theory and alibi are this person's opinion. So I think the left-handmost and right-handmost are opinion, but the rest is fact. So here is sort of the facts. The last text message on Maggie's phone is read at 8:49:27, and the phone is locked at 8:49:31. So we'll just call it 8:50. Right. So Alex is at the kennels at 8:44. Paul and Maggie are using their phones up until 8:50. So they're alive at 8:50. If you go down to this Greenfield, drive to Mom's, 9:06, car is out of park. So he has so if you believe Alex Murdaugh committed these murders, he has 16 minutes tops to commit these murders. This, of course, assumes that he killed them at 8:50. He has 16 minutes tops. In that 16 minutes, he has to clean the scene. He has to clean himself. He has to get rid of the guns, presumably by putting them in the blue tarp that somehow don't have any blood on them, despite the fact that he would have had to do this in a rush. He has to change clothes because he can't go to his mom's house in the blood-soaked clothes he's certainly wearing. He has to potentially shower inside the house, go inside the house to change clothes, get rid of the clothes, get rid of the guns, and drive to his mom's house, all in the space of 16 minutes. On this guy's timeline, at least, he thinks the phone was thrown away when he came back, which doesn't really make sense, but that's what this person thinks is true in the timeline, which doesn't really make sense. So he drives home at 10 o'clock. He grabs the phone. He drives for 12 seconds, somehow gets like a half mile away in 12 seconds, which is pretty impressive, tosses the phone, drives back to the house, and parks at the house. Or in the alternative, he did it earlier, but this person's timeline has him doing it when they come back. So he has him coming back at 10, and he's making the 911 call at 10:06. So that seems kind of implausible. That seems yeah. And then all while not leaving traces of evidence anywhere. Not leaving traces of evidence in the shower, because Sled was there that night, and again the next day, looking in the house with permission. They had permission to search everything. They had permission to search. The next day, they're in the house looking around with his permission to search. They don't see blood. They don't see bloody towels, bloody clothes, bloody shower, bloody drain, bloody anything. I just don't think he can do it. I don't think it's possible. I don't think it's possible. It's a very, very tight time frame. And for it to be possible, it would have had to been meticulously planned out with a goddamn checklist. And everything has to go right. Which, yeah. So it just seems implausible. Thank you. I'm really eager to see the OnStar data. I'm imagining the OnStar data is not going to tell us anything we don't already know. I imagine the OnStar data is not going to tell us anything we don't already know. Like drug addicts are known to be, yeah. This is a very tight time frame to pull this off. And he didn't do this on the fly. He had to have had this plan ready to go. Right? He had to have this plan ready to go. And so basically you're in this position where you believe he gets the call, he's confronted about this check, which somehow gives him the motivation, even though during that very call, he also gets a call, or during that conversation, he also gets a call that his father's in the hospital on death's door. And everyone forgets about the check because of course they do. But you have to believe that Alex Murdaugh had this plan ready to go, plan Omega, in a file somewhere. And he gets the news about his father's on death's door, and he says to himself, tonight's the night. It's my perfect reason for visiting the house. It's where I can dispose of the stuff. I just have to get my family exactly into the place to execute my plan with 2 different guns, and everything has to go perfectly, and I dispose of everything, and somehow don't get blood anywhere in the car, or in the house, or anything, and everything goes perfectly, and I go over there, and I somehow ditch the guns there for a while, and then come back some other time and get them, and blah, 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 blah. This seems implausible. Nicole says, seems just as implausible someone came out to the property without leaving any evidence. Well, not really, because as we've heard at least a little bit, there was a storm coming through that. There's a storm coming through that night. So that helped a little bit. And also Sled was very sloppy in not preserving the scene. So that helped a little bit. Also, this isn't like a game of which is the most likely. At least it's not supposed to be, right? This isn't a game of which scenario is the most likely, and that's the scenario we vote for. This is a game of beyond a reasonable doubt is the game we're supposed to be playing. So we're not supposed to be playing the game of let's consider all the possibilities and let us figure out which is the most plausible, and that's the one we're going to vote guilt for. So even if you consider all the possibilities, and even if you conclude that Alex Murdaugh killing his family is the most probable of the many possibilities, the question isn't is it the most probable. The question isn't is it the most likely. The question isn't is it the most reasonable. The question is it proven beyond a reasonable doubt? No. I have many reasonable doubts. This seems implausible. There's other scenarios that seem very plausible. Even if I concluded this is the most plausible, that is not the right standard. The right standard is beyond reasonable doubt. See, I'm under no particular burden to give you an alternative explanation. That's the idea, right? We're supposed to presume innocent until proven guilty, right? He's presumed innocent. I don't have to give you an alternative suspect. The state has to prove he's guilty beyond reasonable doubt. So if I'm like, well, they haven't proven a guilt beyond reasonable doubt, and you ask me who's the real killer, I can be like, I don't know. I can even do you one better. I can even say not guilty, and you ask me who's the real killer, and I say Alex Murdaugh. But you just voted not guilty, right? But you think he's the real killer? Yes. How can you do both those things at the same time? And the answer is because while I might think it's the most plausible, while I might think it's the most likely, while I might think it's the most reasonable, I do not think they've proven it beyond a reasonable doubt. So he gets away with murder? Well, that's our system. That's the law. What do you want from me? We're doing this by law, right? So is he a murderer? Will he get away with murder? Maybe. But that's the way it's supposed to be. That's the correct answer. If you don't prove it beyond a reasonable doubt, he's supposed to get away with murder. That's the correct answer. Because the state fucked it up. So, that's the right thing. So, I'm not telling you not to think Alex Murdaugh is a murderer. I'm not telling you to think that. I don't think that. But if you want to think he's a murderer, okay. But do you really believe the state has proven it beyond a reasonable doubt with this evidence? What evidence is convincing you? What evidence is convincing you beyond a reasonable doubt? You don't have any reasonable doubts? I have many reasonable doubts. So, if he's found guilty, what are the appellate arguments? Best appellate argument is the financials being brought in. The scope of the financials is too broad. Under 404B and 403, I think is probably the best appellate issue. You could also, of course, try to appeal on the basis that the photos of the autopsy were too gruesome and too prejudicial. I haven't seen them. They're sealed, but that would be an obvious avenue of attack. If it turns out the OnStar information is really, really damning, then unfair surprise would be a good one. What else could you appeal on? Those are the ones that seems most obvious. I think the financials help the defense. The defense have turned it into their advantage, to be sure. But the question that was asked is, what are the best avenues for appeal? And the best avenues for appeal are what I said. I didn't say that any of those avenues would necessarily win, but those seem like the best ones that seem plausible. So the ability of the defense to capitalize on that and use it to their advantage is a very good thing. But the judge may have made legal error in admitting it anyway, in which case that would be a basis to appeal. Venue, maybe. Not a bad idea. You can't get a reasonable jury from this jurisdiction. The problem with venue, of course, is that they went to such effort to find a reasonable jury in terms of the process. They did what you're kind of supposed to do, which is just to expand out the voir dire. And they expand out the voir dire to be apparently the entire county, basically. But venue's not a bad idea. Venue could work. Did they waive venue? I don't think they waived venue. I don't think so. I think they asked to move it. I don't know why you think they would waive venue. I don't remember them waiving it. Have they waived OnStar issues? Not yet. If they think it will be helpful, but if they make an objection and be like, we looked at it and we think it's just unduly prejudicial, we think it's just unfair surprise, they can still raise that issue. It is admitted yet. I don't think they've waived it. The discarded wedding ring that was found in the car after SLED apparently searched the car. So SLED searched the car and apparently didn't find the wedding ring. And then whoever it was, the housekeeper or the carekeeper or whatever it is, I found the ring under the car. Yeah, I don't know about that one. Yeah, you take your rings off when you go to Stables when you get your nails done. That makes sense. I discarded but properly placed by SLED. Well, I was thinking it was properly placed by the person who found it rather than SLED, but is there a definition of reasonable doubt? I can give you sort of the colloquial definition of reasonable doubt. The exact way it's phrased in the relevant jurisdictions will differ slightly, but I'll give you the sort of all-purpose definition of reasonable doubt. The all-purpose definition of reasonable doubt is the level of doubt that would cause a reasonable person to have pause in their most serious personal affairs. A classic example of which is the decision to get married. How sure should a person be before they get married? And that's the sort of thing we're thinking about. Like how sure should you be? Now, one could quibble with that example given the divorce rate, but let's not think about it too hard. So apparently beyond reasonable doubt means people fuck it up all the time. But let's not worry about that factor too much. But that's the sort of poor man's version of reasonable doubt. The level of doubt that would cause a reasonably prudent, ordinary, common person, ordinary, prudent, common intelligence, the man on the bus, the everyman. What would cause the everyman to have pause to do something in the most important and serious affairs of his life? That's reasonable doubt. In brief. Common people aren't intelligent enough to make these decisions. Well, for better or worse, we have a jury system, and so the everyman is your judge. So these are the realities that we deal with, for better or worse. So, Why didn't he police his brass? That's a good question too. New York. Well, I just remember, I just remember the saying. I forget if it was hit from hitchhikers or something like that. It's just like consider for a moment the intelligence of the average person, and then remind yourself of the reality that half the people are stupider than that. So, yeah, good times. Thank you, Nicole, for becoming a member. I appreciate it. Appreciate everyone who wants to join a member. Yeah. Wasn't it Churchill who said the best argument against democracy was 5 minutes with the average voter? Yeah. I look so happy. Or is it sad? Do I look sad? Do I look sad? It looks like sad. I don't know. Do I look sad? I was doing pretty good. Maybe because my eyes leak. Who cares what they think? I care about what you guys think. I care about your collective feedback. You're my audience. I care what you think, at least a little bit. Also, I took it as an expression of genuine concern. So if someone really thought that I looked sad to the point that they thought it was important to say so, then I took it as a note of genuine concern. And so I responded to it as though it were a note of genuine concern. That was how I responded to it. That was how I responded to it, assuming it was a note of genuine concern. It's one person? Maybe that doesn't matter. Want to play the Alex Murdaugh cam video? Give us your thoughts on that. Yeah, I mean, I saw it earlier on, but we could respond to it. Let's see if I can find it real fast. If I can find it. I mean, I don't really know. There's a whole lot of value in it because I don't know what I'm going to be able to say about it, but we can watch it together. I mean, the reasonable doubt mindset, very much so. Yes, very much so. I think we are. I think we are well into reasonable doubt. I'm a pretty solid not guilty vote right now, especially because the state's case is coming to a close and it's not going to get any better in the next 2 days. If they haven't made the case at this point, they're not going to come up with a bombshell in the next 2 days. So. I mean, the thing is, I find it difficult to read people, generally speaking. I'm not a great person when it comes to reading people. I prefer more objective things, and make more objective arguments. Let's see. Like I have trouble reading Amber Heard, quite famously. I have trouble reading many people, and I have very intellectual reasons for that. Like the reasons I have trouble with it are intellectual in their nature. We've discussed that a little bit before too. All right, so we can watch this thing from Long Crime for whatever value it has. I'm not sure it has much value, but we'll give it a shot.
Almost 11 seen and secure. Got a whiskey fox, whiskey Mike, both gunshot wounds to the head.
But let you know.
I wanted to let you know because of the scene. I did go get a gun and bring it down here.
It's in your vehicle? Do you have any guns on you at all?
No, sir. It's leaning up against the side of my car.
Okay. You're fine, man. You're fine. Turn around for me.
I don't have any.
Okay. Yes, sir. I see that. Okay. This is your wife and son?
I'm fine.
Okay.
It's bad. It's bad. I'm shaking pulses.
Yes, this is the firearm you brought from inside the house?
Yes, sir. This is a long story. My son was in a boat wreck a few months back. He's been getting threats. Most stuff has been benign stuff we didn't take serious. Okay. He's been getting like punched. I know that's what it is.
Okay. When did you get home? Right when you called, or did you go to the house first? Where's the house?
I came to the house first. My mom has late stages Alzheimer's, and my dad is in the hospital. Okay. I left. I don't know what time. I can go back on my phone and tell you the exact time. Did you check?
Did I check what?
Did you check them?
We got medical guys that are. That's what they're gonna do. Okay.
What are they doing? Can they hurry?
They are. Yes, sir. That gentleman that was out here already. He's one of the battalion chiefs. Okay. How did you pull up? You from back there?
I went to the house and they weren't home, which was odd. I tried to call.
Okay.
And then I knew they had been down here before I left to go to my mom.
Okay.
And so that is loaded.
Okay.
You might want to unload it.
Is this the only firearm with you? This is the only one, or is there any more in the truck?
I believe that's it.
You think that's the only one?
I'm 99%.
Do you normally have any other firearms in your vehicle?
I don't, but occasionally there's a pistol in there.
Okay.
I mean, it just doesn't mean anything to me, guys. It just,
Wait right here for me for a second, okay?
I am just the wrong person to ask about this. I am the wrong person to ask about this. I'll tell you why, and I'll tell you exactly why I'm the wrong person to ask about this. I pursue these things in a very sort of intellectual way. I look for consistency in rules, right? In case like you need a window into my psychology. Okay? I'm a very sort of process-oriented person. I'm a rule kind of based person. I tend to look for things in rule, not result, right? If I come up with a result I don't like, I tend to look for mistakes in process. And if I need to make a correction, I try to universalize the change, right? I don't like to make changes on a one-off, because that's not great. I'm a big fan of the philosopher Immanuel Kant. Immanuel Kant talks about categoricals, right? Things are true or they're not true, right? Things are always or they're never. Right? It's a categorical. And so he said, among other things, that the only truths that are truths are truths that can be maximized without contradiction. So if it's only true if it can be taken to its extremes and not break. So I give you that background to now tell you this. One of the things that we have, or at least I have heard as a person in society, is that there is no right way to be a victim. You hear this, for example, in the particular context of DV or SA victims, right? How much have we heard about this? About the concept that DV victims shouldn't act a certain way, SA victims shouldn't act a certain way. If they do certain things, it might defy our expectations, and we shouldn't expect them to act a particular way, and they might act in ways that might surprise us. Well, if taking things categorically, I'm like, well, if that's true of SA victims and it's true of DV victims, for it to be true, it must be true of all victims, because it's either true or it's not, right? That's the whole idea of categorical imperatives. If it's true of an SA victim and it's true of a DV victim, then it must be true of all victims, right? Now, I would just like to kindly remind everyone at this point that the presumption legally is that Alex Murdaugh is a victim because he's innocent until proven guilty. If he's innocent, it must be that he's a victim because he's not a perpetrator, right? If he were a perpetrator, he'd be guilty, but he's not. He's innocent, therefore he must be a victim. Our presumption is innocence. Our presumption is victim. Thus, when I watch this tape, I am just applying rules. I'm applying rules. I'm looking at him and being like, my presumption is that he's a victim. My presumption is that he's innocent. I've been told that victims can act in all kinds of ways. I've been told that victims don't behave in particular ways. And therefore, when I watch his behavior, like, what does it mean to you? I'm like, it means nothing to me. It means nothing to me because you've told me it's supposed to mean nothing to me. Or society has told me it's supposed to mean nothing to me, right? It either has meaning or it doesn't. Does a way a victim's act have meaning or doesn't it? Right? So so I tend to think very categorically. So I am the wrong guy to ask about this because I watch it and I'm like, well, he's acting in this way. Is that the way a victim would ask? I'm not allowed to ask that question. So I don't ask the question. So that's sort of why in a technical sense, right? That's why in a technical sense, I view things the way I do. So I watch this and I'm like, well, is he acting like a victim would ask? I'm not allowed to answer that question, or I'm not allowed to ask that question. So I'm not sure why people want me to view the video. I'm like, okay, that's interesting. So, I mean, it does nothing for me. So I tend to view things that are more objective. I tend to view things that are more objective, or things that really stare out. So, you've just been through a traumatic episode. Again, presuming he's innocent, which is our default presumption, right? That's our filter. We're not supposed to start neutral, right? The rule is we presume innocent. We don't presume neutrality. We presume innocence. We presume innocence. Our presumption is victim. Our presumption is innocence. Okay. He is therefore ab initio a victim. He has seen the blown up brains of his son. Would he act sad? Would he act angry? Would he remember everything that happened in his day in crystal detail? Or would he forget things? Would he say things with clarity? Or would he just say all kinds of shit? And would it be possible that those answers might change from moment to moment as the adrenaline and other sort of feelings he's having are creating their cascades through the person's body? Might it be possible that one moment he would be rational, the next moment irrational, one moment cogent, the next moment not cogent, one moment remembering everything, the next moment forgetting everything? Would it be possible for him to say something one minute and the next moment say something completely contradictory? And it might be possible for him to say some stuff and him not even realize that he's saying it just because his mind is working at 1,000 miles a minute. So, because I'm supposed to, not judge a victim based on their behavior, I don't. And therefore I'm the wrong person to ask. Also, if he's acting, he's a better actor than I ever heard. So my rules do eventually break. There's a point where I could be like, okay, no, this doesn't work. So, because I'm not as although I'm heavily influenced by Kant and he's by far my favorite philosopher, I don't know if he was right in his most extreme, which Kant is all about most extreme, but still, like, I don't know if I can quite take Kant as far as he wants to go. But, there's a point where it breaks down, and that point we found with Amber Heard at least. So, yeah. Able to take from experience and relate to what he's being feeling? Hell no. No, not even a little bit. Not even a little bit. I don't think any of us can. I'm not sure. I don't know that many of us have been in any experience that's even remotely comparable to this, right? Have I been in any experience from which I could What was the question you asked me? Am I able to take from experience relate to what he may be feeling? Not even a little bit. No. Perhaps unsurprisingly, I have not had any experiences in my life that come even close to anything that we're talking about. So no, I cannot extrapolate from my life experiences and be like, well, I've been through a similar situation and this is comparable, and so I would have reacted da 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 da. And if you've been through a situation that's comparable to this situation, well, yeah, I don't think many of us have been in Dineges kicks ass too. He kicks ass. Dineges is a great one. The original cynic. Yeah. So I doubt there are very many of us that could reasonably relate to what's going on there. And even if you've been in a situation similar, I'm not sure how much that would be informative. Because unless you've been in a lot of these situations to become numb or used to it, I would imagine that your reaction would be unique. Are the prosecutors going to be able to admit the other 99 indictments? Well, they're going to ask about the financial crimes for sure. Yeah. The rumor mill apparently today, the rumor mill is that Alex Murdaugh is thinking about testifying. I don't know about that. If he testifies, it'll be a very interesting cross. I don't think it's a good idea either. I think it's a problem. Why would he testify? I don't know. Because he's an arrogant egomaniac like most lawyers. Are they capable of a good cross? That's a fair point. Has any lawyer ever testified in their own murder trial? I'm sure it's happened. Wouldn't recommend it. He probably should know better, but people do some dumb things. They're definitely going to ask him about the financial shit. Of course they are. It's all relevant now. And yeah. And that if he testifies, that arguably renders moot some of the issues that are pending. Will that be something the defense would make public? They're floating it as a trial balloon to see how people react to it. That would be why. They're floating it to see what people's reactions are. Possibly induce the state to take some sort of steps that they might be able to learn something from. That would be the reasons why. Can he appeal if he loses? Sure. I think he has some reasonably positive appeal possibilities. Appeals are for losers, but the financial stuff is just so broad that I think that there's reversible error. He'd be crazy to testify. I think so. The state can't appeal if they lose. That's true. Yeah, the state can't appeal. Double jeopardy and all. They can in Canada apparently, because Canada doesn't believe in freedom like we do in America. So in Canada, the state can appeal legal error, but not in the United States. So if a judge makes a legal error that prejudices the prosecution in the United States, so sad, so sad. It's a sad, sad situation. But yeah. So if the judge screws up by like not letting in evidence or not letting experts in or whatever, yeah, the judge can basically sabotage the case completely for the prosecution. Judges have insane amounts of power, and a judge can go way off the rails. And it's not known to happen often, but it has happened before, where a judge just goes completely off the rails and just starts disqualifying the state's witnesses and experts and even fact witnesses, and basically be like, this person's not going to testify. What do you mean they're not going to testify? Yeah, they're just not. So yeah, yeah. But we've decided as a society we don't care. So yeah. Doesn't happen often, but every once in a while. I mean, it has to be really bad for anyone to notice, because judges are going to good judges will make decisions that will be adverse to the state from time to time. It doesn't necessarily mean they're wrong. Anywhere they are wrong, it's usually like, well, it's just the way it goes. The defense gets to appeal, so sad. Yeah, if he takes a stand, those questions will come in. And the appeal will just go to retrial, yes. Is the video footage over? Yes, because I didn't see any further value in covering it. We watched a minute of it, and I didn't see any further value. Would you like to watch more? We can. I'm not sure why, but we could.
Enjoy it, sir. And while already spoken on deal, we've got Ron Sainz in contact with him. He's also going to give us the assistance with a couple of violations. Cover that?
Say all that on it.
Yes, sir. That's what it looks like.
What are you, man?
I mean,
All right.
I don't really know what I'm supposed to be looking for. I find his behavior consistent with a man who just found his blown out brains of his son and shot wife. I think I'd be losing my shit more. But I find his behavior consistent, although I'm not really supposed to not really even sure what I'm supposed to be looking for when I'm asking that question, because consistent in what respect? Because I'm not supposed to ask that question. So question, yeah, I don't, okay. Yeah, it doesn't do anything for me. It's totally his voice on the video. The defense basically already conceded that in their opening anyway. All right. He has to explain the lie. No, Luke. He has to explain the inconsistency, not lie. Lie is presuming his intent to deceive. He has to explain the inconsistency. But it's doable. It's doable. You mean lie? I'm not sure on what basis you're drawing that conclusion. All right. Well, that appears to conclude our stream for tonight. Thank you very much for all of you guys who jumped in on the stream. By the way, thank you for all of you guys who've been buying so many memberships lately. I've really been appreciating it. We've really done really well recently on the whole membership things, and we're only 230 subs away from the next 1,000 milestone. That's pretty cool. Also, 5 days ago, we passed 10 million total views. That's pretty cool. So that's really encouraging, all things considered. Yeah, memberships are up quite a lot in the last month. So that's really nice. That's awesome. I'm really happy with all that's doing. In terms of the channel, in terms of what I want to do going forward, I think tomorrow I'm going to take an opportunity to try to experiment with something, just to see what one looks like as a style. So what I'm going to do tomorrow is I'm going to record a video on something. I'm not sure what, but I have some ideas that I can look through. I'll find something that looks interesting that's legally related, and maybe I'll do something on the Chinese weather balloon or something. I don't know, the law related to that or whatever. So I'll do a video. I'm going to record it, edit it, and I'm going to put in some more B-roll than I normally do with some like stock images and stuff, and see how that helps, and potentially release it tomorrow in the evening as well, and experiment with trying something a little bit different in terms of the presentation format to make things a little bit more interesting. So that's what I'm planning on doing tomorrow, I think. Double Jeopardy conspiracy issue. I've done a video on that already, but I suppose I could deep dive it more, really do something more thorough on it. But yeah. But I think I'll do that tomorrow. And then Wednesday and Thursday, Rakita isn't streaming, so I might stream Wednesday or Thursday. Maybe Thursday or late Wednesday with the start of the defense's case would be good. So I might pick it up again with the start of the defense's case if they start on Thursday. So go from that. Time to increase the membership price. Well, one of the things I want to do is make it as accessible. You know, if I have more people at 99, a lot of people at 99 cents makes things accessible. And there are higher membership tiers if you want to pay for a higher membership tier, but very few people do. Almost nobody does. There's a few people. There's like 32 people right now at the $5.99 level, $3 at the $9.99 level, and $5 at the $19.99 level. So there are currently 40 people total at the membership tiers beyond 99 cents. So it is not a very popular. It's not a very popular thing. So if you want to pay for a higher membership, it is available, but it's just not very possible. It's not a very hard thing, and I want to make it really easy for so many people to join. I'm working under the premise that having a higher percentage of people as members is a good signal for the channel. So I think even assuming the same amount of revenue, I think having a higher number of members is good. So I'd rather have, please don't make me do math, but I'd rather have 5,000 members at $1 each than 1,000 members at $5 each. Yeah, that works. So yeah, that works as math. I'd rather have 5,000 members at $1 each than 1,000 members at $5 each. That's the same amount of revenue, but it's 5 times as many members. And I think that's probably a positive signal, I'm guessing, for the channel and stuff like that in terms of helping to promote the channel, things like that. So, plus, I know from my own experience that those memberships can really add up. When you're doing $5 at a time, like I haven't used Patreon in a long time. But I remember when I used Patreon, and like I would do all those like $5 memberships. Those add up after a while, and suddenly you're spending a lot of money. Like, man, this is a lot. So I wanted to make it really inexpensive, so that everyone would do it because it's $1, and that's more doable. So I want to make it more accessible. So all that good stuff. A weekly member only stream is not the worst idea. Weekly member only chat, at least that'd be good. So that's the idea. And we do have the locals page if you want to contribute that way as well. Cost of memberships, why didn't cancel when we're cutting things to buy a house? See, there you go. Right? Just make it really, really inexpensive. And gift memberships are really nice because they wind up as a free advertising tool. They're free from your point of view and also from my point of view. They're just free. So it's better for me. If you bought, like, it is better for me for you to buy 5 gift memberships than a $5 super chat. Right? It doesn't cost you anymore. In fact, it's slightly cheaper because it's only $4.95. It doesn't. So it's basically the same cost to you, right? $5 in super chat versus 5 gift memberships is the same cost to you. It's the same in immediate revenue to me. I get the same percentage split, but it serves as a free advertising tool because now I have 5 people that have a free membership, and some of those people may choose to buy their own membership or buy other memberships. So it feeds into itself. Like, I don't know what the conversion rate is. I haven't done analytics on the back end, but you know, if it's anything, it's more than 0, which is like the super chat, right? Super chats have a 0% conversion rate, right? You buy a super chat and that's it, right? It doesn't do anything. You know, if 100 people, if people buy 100 gift, so if someone bought $100 super chat, right? It has a future rate of 0 because, like, it's $100 super chat and then it does nothing. If someone buys $100 worth of memberships, you know, if 1% of those people choose to buy their own membership, then it had a 1% growth rate, right? And hey, 1% growth rate feeds into itself, right? Because then 1% of those people will buy, and so forth and so on, right? So it will become something that, you know, it's probably more than 1%. It just points out that anything is more than nothing. So that's the idea, at least. These are all behind the scenes, way too much discussing. So there's a potential of some amount, I'm not sure what it is, but it's a potential of some amount that some of those people will choose to buy memberships themselves going forward. And some of those people might choose to buy because they've seen basically the ad, because they get the email, hey, congratulations, you got this membership. Some of them may choose to buy memberships, and so on, around we go. So it has some sort of ongoing conversion that's more than nothing. So I figure it's got to be better, right? As long as it's more than 0, it's got to be better. So that's my philosophy, or that's what I'm thinking is true. So that's why things make sense. And you get some cool emojis. By the way, if you ever have an emoji idea for the emojis, if you just want to, like, tag me on Twitter or something with an emoji that you design that I can just add, I have space for like 30 different emojis more I can add. I just don't know what to do because I'm not creative in that way. I have some emojis now, but if there's like emojis that you guys want and you guys can send to me, I'll add them as long as they're, you know, brand appropriate for the channel and, you know, that seem interesting. So if you design an emoji or you see one that, you know, we can use from somewhere that you like, you know, tag me on Twitter, or tag me on Discord with the thing, and I'll add it. And that'll be good. So, you know, just remember when you're designing them, they have to look really good, really, really small. So they have to be really simple because they have to look good in really, really small size. So, yeah. But if you ever want to design an emoji for the channel, tag me on Twitter or Discord, and that'd be cool. Yeah, I don't know how to design emojis either. I don't have that particular skill set.
Good morning. Mr. Griffin?
Before we bring the jury in, I would like to put on the record the basis of my objection to the redirect of Agent Owens regarding the roadside shooting. Understanding the court's ruling was that I opened the door to that based on my cross-examination. This is the first case I've had the benefit of being able to go back to YouTube and see exactly what was asked on direct and what was asked on cross. I have typed it out. It's very brief. On direct examination, Mr. Meadows asked Agent Owens question at some point in 2021 in the fall, did a financial investigation begin at Alec Murdaugh? His answer was yes, sir. Question, would it be fair to say that the investigations overlap with each other? Answer, it did. Question, would it be fair to say that the two investigations fed off each other? The answer is yes, they did. From the information I was learning from the financial investigation, it gave me additional people to consider and to look at Mr. Murdaugh as a reason why or why not. The next question, were the individuals in the finance investigation that you also interviewed in this investigation? He said, yes, I did. And the question, did you learn information from the grand jury testimony? He says, yes, I did. And the question, did you follow up on that information? He said, yes, I did. That was elicited on direct examination. My cross-examination, I began on this topic. You also testified in the fall of 2021, there started up a financial investigation. Yes. You said it fed off and overlapped with the murder investigation. Yes. You developed information that Alec was stealing money to support a drug addiction. Yes, that was reported. Question, you learned that Alex was paying up to $50,000 a week to buy drugs. Yes, that is what was reported. You learned that Alex was buying from Curtis Eddie Smith. Yes. You learned that Eddie was buying from the Sand Hill drug gang. Yes. You learned that Eddie owed the Sand Hill drug gang a lot of money. Yes, but they were not worried about getting their money because it was Murdaugh. Question, did you ever conduct a cell phone analysis of the Sand Hill drug dealer's cell phones to see if they were at Moselle on June 8th? Answer, no, because in my experience, they use burner phones. Question, you never got DNA from them to cross-check against the unknown DNA on Maggie's fingernails. Answer, no. Question, you never put them in the investigative circle, did you? Answer, my understanding is that investigation is continuing and is being conducted by the DEA. And from that, Your Honor, there were no questions related to the roadside shooting, no questions related to whether Alec lied to the police in connection with the roadside shooting. It was all about him stealing money from clients to support his drug addiction, which is evidence that was already in the case. Your Honor, I sent the court via email earlier today, the case of State v. Hayward, 426 SC 630, which is a 2019 case where the Supreme Court reversed Judge Young on opening the door theory.
The same Supreme Court reversed the Court of Appeals.
Excuse me, the Supreme Court reversed the Court of, sure. The defendant was convicted. It went, the Supreme Court, the Court of Appeals affirmed, and the Supreme Court reversed the Court of Appeals. That's right. And vacated the conviction based upon the introduction of propensity evidence, 404 evidence on the theory of opening the door. And in that opinion, Justice Hearn is very specific to state that the courts have to be very careful and very wary of thinly veiled attempts to show propensity by way of the open door doctrine, and that the testimony and response must be proportional and confined to the topics to which counsel had opened the door. And again, I go back, we did not open the door to any roadside shooting, any insurance fraud, anything with regard to Alec lying to the police. And so that was the basis. I just objected, so I want to put that in the record. Today, they intend to present a full panoply of evidence on the roadside shooting. And Your Honor, we would oppose that.
What do you mean a full panoply?
Well, they've asked to, that they're going, my understanding, they're putting up Agent Kelly to talk about his investigation of the roadside shooting. We got a request this morning for them to play the hospital videotape of Alec in the Savannah Hospital, which is over an hour, where he's being interviewed by SLED agents, and he's meeting with a sketch artist to draw up a sketch of the roadside shooter. And that they plan to introduce that evidence. They plan to introduce, as we understand it, follow-up evidence of when Alec gets to detox in Atlanta, when he calls back with Mr. Harpootlian and I, and he gives a full statement about the roadside shooting and about how he had lied to them previously, how he was sorry.
Is that the same video or
Two separate. I mean, second is just an audio tape. But Your Honor, I just go back to State v. Hayward, where the court says testimony and response must be proportional and confined to the topics which counsel has opened the door. And so they intend to spend 3 hours of testimony here today, and it's not proportional, and it's not related to the topic for which the court, I believe, should find that. I don't think I opened any door because I think the evidence was already in the case.
All right.
And it was in response to direct. It wasn't something I brought up.
May it please court, Your Honor. To go back, obviously, we had this issue and we addressed it yesterday morning.
This time we're dealing with the issue of the court's, the exception or statement for the record that Mr. Griffin wanted to make concerning the court's ruling yesterday. We're not dealing with any anticipated testimony today at this time. I'm not ruling based on what, well, I've already ruled, but I'm entertaining these comments for the record regarding yesterday's ruling. So go ahead.
I think, Your Honor, if you listen, obviously, to the excerpts that Mr. Griffin just read, and you put that in the context of everything that had developed, starting with Marion Proctor, that the door is more than opened, and the state's intent in that regard is to fully respond to and flesh out the very examination.
The state's intent in that regard. We're talking about yesterday's ruling, so we can close the door on that. Do you have anything else to say about the court's ruling?
No, other than the examination, the redirect examination clearly was in response to and appropriate opening the door after that examination, and that's I think that Your Honor's ruling was appropriate in that regard, and I think that again that has opened the door to exploration of those issues.
Concerning the court's ruling yesterday, and also State v. Hayward, Mr. Owens, in questioning Mr. Griffin and cross-examining investigator Owen, got into this circle of interest that Alex is in the circle, then cross-examined the witness regarding, did you consider Eddie Smith to be in the circle? Well, did you consider some unknown gang members, whoever they might be, to be in this circle? Did you know that Alex was spending $50,000 per week supporting a drug habit, presumably through Eddie Smith, and that he owed money or he was indebted? So Mr. Griffin introduced the relationship between the defendant and Eddie Smith. The court conducted a pretrial, a hearing outside the presence of the jury, addressed the issue, made it clear that the roadside shooting was a bridge too far. Then the defense decided to build a road over that bridge, decided to just go right there as if they could dance through fire without getting burned, scarred, or anything. The door was open. This is not the same as the situation in State v. Hayward, where a co-defendant's, a cooperating co-defendant is being questioned about unrelated matters, totally unrelated to the case, and the Supreme Court presiding judge went too far in allowing evidence not proportional to what was open and which he already ruled should not be introduced. I find that what this court allowed on yesterday was proportional because it was in relation to evidence elicited not by the state, but by the defendant. And the state is entitled to explore this relationship between the defendant and Eddie Smith. And then we'll have further discussions at some point regarding this limitation of just randomly throwing out names of people, or suspicions and speculations regarding on the issue of third-party guilt. But to the extent that the defense sought to introduce the relationship between the defendant and Eddie Smith, and then to seek to infer that Eddie Smith might have been or should be a suspect in the murder, then to prohibit the state from saying, well, if he's if Eddie Smith should be a suspect, and Mr. Murdaugh, who at the outset engaged in his form of problem solving by telling the state what this case was all about and the murder was all about, meaning the boat crash, then later engaging what appears to be a conspiracy along with the person that the defense seeks to insinuate to be or should have been a suspect. The state is entitled to explore that. The extent to which the state should be entitled to explore that, that's open for discussion today, but not based on the court's ruling yesterday. The court in the Hayward case did indicate that the court should be careful. There's the nature and extent to which these other matters should be allowed to go into, and I intend to do that. But the record is protected to the extent that Mr. Griffin went through YouTube and citing what his version of what he said yesterday, excluding the portion that's more relevant and important to the court's ruling. But the record speaks for itself on all of that, and the court's ruling stands as it was given on yesterday.
Your Honor, obviously we would accept your ruling, but there's...
Okay, we have a ruling, we have for the record, now we have an exception to the ruling, and another comment. Go ahead.
So, what I'd like to discuss now is what the state will be allowed to submit in support of this position. Now, clearly there is a taped statement by Mr. Murdaugh from a detox facility in Atlanta, which was initiated by Mr. Griffin and I. So certainly there's no objection to that. I mean, there could be, but no real objection to that. Secondly,
no objection to the statement.
Well, no objection to the statement pursuant to and conditioned by our previous objection to, I want to make the record clear. We're objecting to any of this.
Oh, I understand. You've objected to everything throughout the trial. I understand.
Well, there's a couple things we missed. We'd like to rehear some of those, but Your Honor, but then, and again, Mr. Water and I discussed last night after ruling, a way perhaps, I know this is shocking, to expedite this process. For instance, there is a statement made to EMS, the statement they're wanting to get to, which is, drive-by shooting, all those sorts of things, which he later on admitted in the telephone conversation statement that was taken, was not true. We get that. It didn't need to be Mirandized on the side of the road by EMS. However, there are two recorded statements taken at the Savannah Hospital by Agent Kelly after he is, and we've got the medical records here if you want to look at them, but clearly has suffered a wound to his head, a fractured skull.
Always suspect of that word clearly and clear. Everything is in controversy.
I think this is in controversy.
Tell me what's clear again.
Bullet wound to the head, fractured skull, brain bleed. That's not contested. The medical records indicate medication that he was under while he was at the hospital. We would think there'd have to be a Jackson v. Deno hearing on those interviews, just under the issue of, was he competent, a competency hearing. To do that, we would have to bring the physicians and the treating physicians from Savannah here to testify. And again, and I think Mr. Waters will concede, it was at 6, I emailed him and said, all good, what we talked about yesterday. He came back a little while later and indicated that he'd like to put those in. Mr. Griffin and I, over a cup of coffee, said there's competency issues. And we informed him that this morning. Nobody's playing gotcha here. So we don't believe those should come in without Your Honor being able to rule that he was competent, hear from the doctors. And I think we may have worked out a compromise on that. I just want to confirm that for the record. But what we have worked out is this. The statement that he would not have to bring the EMS people. There's a statement that they made. Agent Kelly can publish that statement without having them need to be here. There was a knife recovered at the scene. They don't have to Kelly can identify that. There was a,
Your Honor, so what we talked about yesterday, just to kind of wrap this up, was again, my intent to do this in a very expedited and focused fashion, not get into every detail or litigate that entire matter. And I suggested to the defense, and they agreed yesterday, that I could have Agent Kelly, who's the lead investigator on the side of the road, come up and essentially, in a very abbreviated fashion, walk through the case without the need to call the 911 operator or the ambulance driver or the roadside deputy or the DNA analyst or the person who found the knife and so forth and so on. And I plan to do that, again, in a very expedited fashion. I'm not talking about anything 3 hours or the like. We also discussed this morning that I do need to be able to relate to the jury, though, the defendant's claim, which I have argued to you is particularly relevant, that he was attacked by an unknown assailant on the side of the road. And in fact, he knew exactly who it was. He had actually arranged for it. And so our discussion that I thought we had an agreement on, I think we still do, is that Agent Kelly, there was an interview in the hospital on 9/4 and one on 9/6, and that I would have Agent Kelly just summarize and reiterate the defendant's claim about what happened on the side of the road, as well as the fact that he worked with a sketch artist and show that sketch picture, and then just move through it like that. And then we will play for the jury, which I think they just said they don't object to, or no additional objection, the telephone interview in which he ultimately admitted to law enforcement in the presence of his attorneys that it had been a lie.
Yes, sir.
That's the deal. But I feel a little more comfortable if we could just have, and I'm not trying to delay court, but this recording is 47 minutes long, 41, whatever, 40 plus. So many recordings, I'm confusing them, but 41 minutes long. Could we take, I mean, if you could just, and by the way, I've agreed to allow him to leave unless I see something reprehensible going on, which for me is difficult to restrain myself from objecting, which would expedite it even more. But at 6:30 this morning, we were not in a position to discuss what Agent Kelly, what we sort of acceptable, what happened at the hospital thing. I just like 5 or 10 minutes just to review that with him, and then I think we're on go. Although, just for the record, we're objecting to any of this. I don't want this kumbaya moment to be viewed as any waiver of our objections.
The only thing I just want to put on the record again is that in discussions with the defense counsel, moving expeditiously with Agent Kelly without raising hearsay and that sort of thing and making us go through our paces has been a strategic decision that the defense has made.
Pursuant to the, I just want to make it clear, I hate to sound like a broken record, but I don't want any appellate court ever to look at this and say, well, you agreed to it. We're agreeing to this process pursuant to your Honor's ruling this morning.
I have not reviewed any of the evidence that you all are now referencing. So to the extent that you all have an agreement on moving forward with this evidence, considering the objections, I'm fine with taking 5, 10 minutes if that will expedite things. I deal with what you all disagree on, not what you agree on.
We're going, if Your Honor, when you take this recess, we're going to take myself, Mr. Griffin, maybe even Mr. Barber, to, he seems busy, to a room where we can have some peace and quiet and have a discussion without being interrupted every 2 minutes.
All right. We'll be in recess then for hopefully about 10 minutes.
All right, make it order.
State's case, cross-examination, Mr. Barber.
No questions, sir.
All right, thank you, sir. Call your next witness.
Thank you, Your Honor. We call Dr. Kenny Kinsey.
Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God? If you would, please, sir, be seated in the chair over there. State your full name for the record, spell your last name, and try to talk in the mic as good as you can.
Dr. Kinsey, how you doing today?
Kenneth Lee Kinsey, Kinsey. I'm fine, sir.
Good. Dr. Kinsey, let's talk a little bit about your career and who you are. First of all, just kind of introduce yourself to the jury a little bit and tell them where you grew up and where you went to school, and then we'll start to talk about your law enforcement career and your expert qualifications.
Yes, sir, happily. I grew up a long way from here in a little county called Orangeburg. I was there about 54 years, my whole life. Went away for college a couple times and came back. And I'm currently the chief deputy of the Orangeburg County Sheriff's Office. And I'm also a professor of criminal justice at Claflin University, where I teach crime scene related classes.
All right, and pull that mic a little bit closer to you. Let's first of all, before we get to the professorship and what led to that, let's talk about your law enforcement career. So walk me back to the beginning, and if you could just kind of walk through the various stages of your career and the things that you did along the way that led you to become a chief deputy for Orangeburg.
Yes, sir. I began my law enforcement career approximately 30 years ago, and I've held many positions in those 30 years. But for the last 22 years, my concentration, other than administration, has been crime scene investigations and working violent crime scenes. I have ran the crime scene unit in Orangeburg for 6 or 7 years, and then I went on to SLED for approximately 4 years, and then I came back, and now I directly supervise the captain of investigations, and investigations includes the crime scene unit. So I'm still hands-on on crime scenes, either as a primary or a backup crime scene investigator. And as I mentioned earlier, I teach crime scene investigation and other criminal justice related courses. I received my bachelor's degree from Clemson University in 1991, my master's degree in science from Troy University in 2011, and my PhD from Walden University in 2019 with a concentration on use of force cases involving police officers. And my research is use of force and crime scene investigations.
So we could call you Dr. Kinsey, correct?
My grandmother told me it's what you answer to, but yes, sir, I'll answer to that, Kenny or Chief Kinsey.
And we could call you Professor Kinsey, correct?
Yes, sir, that is correct.
And then we could call you Chief Kinsey as well.
Yes, sir.
Okay. Well, let's talk a little bit more about the law enforcement. Then I want to talk a little bit more about the education. Now, you mentioned that you've done a lot of administration. And tell the jury just a little bit about what it is to be the chief and just what that entails. And then we'll talk a little bit more about sort of the crime scene stuff. If you would.
Yes, sir. I answer directly to an elected sheriff. I'm the number 2 man at the sheriff's office, and I supervise approximately, when we're full, when every slot is full, I supervise over 127 people. 105 are certified law enforcement men and women, and that encompasses about 9 different divisions at the sheriff's office, including narcotics, special operations, criminal investigations, civil, courtroom, school resource officers. There's several groups in there, and our civilian employees.
Now, as you've already testified, you don't just do the administration stuff as a number 2 man, but over your career, you've also extensively done actual law enforcement work, processing homicide and other major crime scenes. Is that correct?
Yes, sir, I have. I have boots on the ground, processed north of 800 death scenes. Not all of those are homicide. That also includes suicides, accidental deaths, and unexplained deaths. That is either as a primary investigator or as a secondary investigator in my career. And I still have a directive that I placed with my coworkers approximately 11 years ago. I still go to every death scene if possible.
And over that time, you said over 800 death scenes over the course of your career. Is that correct?
That is correct.
And then, how many pieces of forensic evidence do you think you've processed over the years?
That would be hard to determine, multiple pieces for each scene, but part of my duties, yes, sir, part of my duties when I was at SLED was to also process evidence that was submitted through the door. And what through the door means, these are items of evidence from other agencies that have worked their own crime scenes, and they send their items to SLED for an analysis. And that's in the thousands. I would have no way to give you a quantitative number.
In the thousands?
Yes, sir.
Is it also over the years, have you attended autopsies as far as your investigative work as it relates to death scenes?
That is correct. Every agency I have worked at had a mandate that you attend autopsies to collect evidence, do major case prints, GSR, and that kind of thing. And also to give the pathologist an idea of your interpretation of what happened.
And have you ever been asked to consult on death cases in jurisdictions throughout the state or even in other states?
Yes, sir, I have.
And describe that to the jury, please.
As a consultant, I work for, to be frank and honest, sometimes it's against law enforcement. Sometimes it's defending law enforcement, just depending on what I believe is wrong and right. And I have participated with private attorneys in the civil process, doing both. And I've also been asked by colleagues and comrades across the country to review a piece of evidence if they may have needed a qualified examiner to technically or administratively review that piece of evidence or their findings.
Before I come back to the specific crime scene training and experience that you have, I just want to go back again to your education. You went to Clemson, right?
Yes, sir.
Right, and started a law enforcement career not long after that?
That is correct.
And what year did you graduate Clemson?
I was on a 5-year plan. I graduated in 1991, and I started as a reserve deputy. The records are a little shaky because back then you worked until they had a certification class, but best I can guess was somewhere around 92, 93.
So 91 Clemson?
Yes, sir.
I was 92 Carolina. All right. Then you went on to Troy University at some point later in your career?
I did, yes, sir. I attended Troy's satellite campus, which is in Sumter, an actual brick and mortar school. And the purpose of Troy being placed in Sumter is because of Shaw Air Force Base. A lot of our men and women who protect our country use their GI Bills to further their education at such campuses. And I had to travel 1 night a week and 2 days a week for approximately a year and a half to complete that pass proficiency.
All right. That competency exam, is that a pretty tough exam?
It's the second toughest thing I've ever done. Yes, sir.
Is the pass rate pretty low on that thing first time?
It is very low. We probably had 30 people in our class, and I only know of 4 that passed the competency the first time. Yes, sir.
And then you went on and got your doctorate, is that right?
I did, yes, sir.
And that was a Walden University program there?
It was, yes, sir.
Did you have to do any residencies with that?
We'll stipulate to him as a qualified expert. If we just go ahead and move on. Thank you.
To explore the extent of his qualifications, that goes directly to the value of his opinion to the jury. I'll do it expeditiously, but I think we're entitled to do that.
Do you accept the stipulation or no?
I do accept the stipulation. I would like to very quickly finish up the qualification process so that the jury understands that.
Ladies and gentlemen, he is so qualified. You may proceed.
Thank you, Your Honor. All right. So real quick, you did some residencies in your doctorate. Is that correct?
I did 4 residencies in Atlanta. Yes, sir.
And ultimately did dissertation and all that comes with getting your doctorate relevant to criminal justice and criminology. Is that correct?
I defended my prospectus and my dissertation. Yes, sir, successfully.
All right. Now let's get to the last thing I want to cover as far as your qualifications. But what specific areas of crime scene investigation and reconstruction have you had training experience and previous qualifications in?
Yes, sir. I have been certified internationally by the International Association for Identification as a crime scene technician. That's a 5-year deal, and then 5 years as a crime scene investigator, where you have to do practical and written examinations, and you have to have statistics in your background, a certain number of each item to even be able to take the test. And that encompasses all of the different aspects of crime scene investigation. My training also encompasses footwear and tire tread examination, bloodstain pattern analysis, crime scene reconstruction, fingerprint examination, and fabric impression, but I haven't done a lot of the fabric impression.
Have you ever been qualified in courts of record as an expert in crime scene examination and reconstruction?
Yes, sir, I have.
How many times?
Approximately 35, 36 times.
Have you ever been qualified as an expert in fingerprint examination?
I have, yes,
How
sir.
many times?
Maybe 20, 25. Sometimes, and let me explain why. Sometimes it's not individually. Sometimes you'll qualify for 2 or 3 of the different disciplines, and I didn't keep track of which time, was singular or which time was multiple qualifications.
All right. And then have you ever been qualified as an expert in footwear examination?
I have, sir, approximately 8 times.
And tire tread as well?
Yes, sir.
All right. I believe that's what I wanted to go through with your qualifications, which I believe you stipulate in those areas. Is that correct? All right. Let's move on. Did you have an opportunity to review at the request of the state the crime scene here as it relates to Maggie and Paul?
I did. Yes, sir.
And just very quickly, what are some of the types of things that you reviewed as part of your process?
When I do a reconstruction, I look at the available evidence as I feel it's pertinent to help me answer some questions. And the questions that or the things I wanted to accomplish from this reconstruction, you can determine sequence, you can determine movement. A lot of times you can determine the number of blows, or in the event of a hand-to-hand combat or a firearm was used, those kind of things. So I examined forensic reports that were issued by law enforcement laboratories. I also examined extensively photographs that were taken on the scene, measurements, that kind of thing. And I also responded to the scene. It was rather close, and I took my own measurements.
When you say responded to the scene, when did you first get involved in this guy?
The end of 2022, and I'm not talking about when the scene was actually going on. I went after the fact and did my own measurements.
Right. And when you were retained by the state in this case, were you told any particular goal, or were you told to just take a fresh look at it and offer your opinions?
I was told to look at all of the evidence and determine what I may be helpful on, and to use my own judgment objectively, independently, and come up with my own conclusions.
All right, let's talk about, if we can, and again, we're going to have to deal with some of, maybe not the images as much, but deal with some of the injuries that Maggie and Paul suffered, correct?
Yes, sir.
Let's, if you could, just remind the jury, what were the injuries that Paul suffered, please?
They were very, very severe firearms injuries. One was a shotgun wound to just a little anatomical left of the midline of the body. One was to the shoulder, and it proceeded into the jaw and ultimately into the head.
And was that the first injury or the second?
The first injury was the shotgun wound to the middle of the chest, and it was non-fatal,
Right.
at least not fatal immediately.
And then what about the second injury?
The second injury was immediate death.
And were you able, in reviewing crime scene evidence, to come to any conclusions as to the order in which Paul suffered those gunshot wounds from the shooter?
Yes, sir, I was.
All right, and please relate that to the jury.
My conclusion was that the first non-fatal wound to the midline of the body occurred as Paul was standing with his body canted in the middle of that dog food room, pointed slightly southwest. and the shot entered the midline of his chest, exited his underarm, entered his underarm on the actual arm, and exited the outside of his arm. And most of those 9 pellets proceeded through the back window of that dog food room.
Right. And then just real quick, you said 9 pellets. So explain that to the jury why you say 9 pellets.
That double-aught buckshot shot shell contains 9 pellets, and I guess you describe it as a styrofoam packing to keep it tight so it doesn't shake. And when that cartridge is expelled out of the end of that barrel, the styrofoam packing dissipates or goes its own way, and those projectiles continue in the correct path.
And hold on for me real quick. I want to get a couple things marked. I'm going to show you, can I have the ammo, please? I'm going to show you what's been marked as states 531, 532, and 533, and see if you recognize these particular images.
Yes, sir, I do.
All right, and tell the jury just generally what these are, please.
These are views of the floor of the feed room and a view from the entrance to the feed room and some digitally placed legs that I placed in there to show Paul's approximate position in that feed room at the time of the shooting.
Your Honor, at this time I'd offer for states 531, 532, and 533, I believe, without objection. Yeah, Your Honor.
There, did it.
All right, I'm going to put 531 up on the screen here. Make sure we can see it all right. All right, Dr. Kinsey, you're talking a little bit about Paul's positioning and his location when that first shot happened. And if you could tell the jury your conclusion as to where he was located when that shot was fired. And then if you want to step down, and if you could maybe point out what was added to this image to kind of reflect your conclusion in that regard.
Thank you.
And there's a dowel stick right behind you if you want to use that.
Okay, as you see here, those are the digital legs that I placed there showing Paul's approximate position as he was standing when he had the first gunshot wound. Here along the floor, what you see are passive or 90-degree blood droplets. And when blood, you can tell a lot from the direction of blood by the way it strikes an object. Blood has a cohesive factor. It's viscous. And you probably heard that term before with the motor oil for your car. It's thicker than water. And the thing that causes that blood droplet to change shape is the friction and the direction and how much force was used. Well, a 90-degree drop just is exactly that. It's perpendicular to the ground. So these 90-degree drops right here tell me that Paul was standing there for a moment. Can't tell you how long, but those drops were running down from that wound on his arm, more than likely his arm, because his chest area had a shirt on it. It takes a little while for that blood to make it through the shirt, but it'll run down the outside of your arm and drip off your fingers. And you can see these 90-degree droplets here, and then they actually lead to the door. You can follow the path to the door. He's not moving very fast because most of them are almost perfectly circular or 90 degrees. Had he been moving real fast, you can see some directionality in him, a tail, because the tail always tells you the direction with a blood drop. So I know he was moving slowly, and I know he was standing in the middle of this room for some time after the first shotgun wound.
All right, and approximately how far was Paul inside the feed room? Can you describe a little bit about the dimensions of the feed room and your conclusion as to how far within the room Paul was when he was struck by that first blast?
Yes, sir. Well, the feed room is 10 foot deep by my own calculations and by looking at the other sketches. And where you see his feet here is just on the other side of the halfway point. So I went, I'm guessing because I have no way of running a tape measure because when I went there, everything was moved. But this door is 36 inches and it's approximately 1.5 foot, 2 foot past the door. So that's how I come up with that determination. And he's just on the other side of the midpoint of that 10-foot room.
Which is about how far from the doorway?
5 foot.
All right. And I'm going to show you what's been marked as 534, stage 534, and see if you recognize that.
I do. Yes, sir.
All right. And tell the jury what that is real quick.
That is a general view from outside the feed room that was taken at the time the crime scene was originally processed. And I added a digital enhanced arrow showing the reader or the viewer the direction of the shot path.
All right. This time I'll offer stage 534. Okay. All right, I'm going to put 534 up on the screen, and if you would, just show that arrow that you're talking about that's been added to this image.
Yes, sir. Right here.
All right. And then, as well, just show generally where those blood spots are. It's not the best image in the world, but where those blood spots are that led to your conclusion about Paul's location within the feed room when the first blast struck him.
The placard hasn't been moved, although it's hard to see the droplets. And, of course, I didn't add the legs to this, but just on the other side of that placard, and then you have here a quantity of 90-degree blood droplets with a partial footwear impression in it. And then you can follow the blood droplets to the door.
Going back to stage 531, again, point out to the jury, if you would, the sort of the digitally added feet that you had added. All right. And if we would, if you could, just if that's the feed room doorway, can you just sort of position me, in your opinion, how Paul was standing when that first blast happened?
That's the doorway coming in.
Yes.
About right here.
All right. And let me ask you this. In your review of the evidence and the available crime scene evidence that you've reviewed, in your expert opinion, is there any way that Paul's arms were raised when he suffered that first blast to the chest?
I see no possible way his arms were up when he suffered that first shotgun wound.
And can you explain the basis for your conclusion to the jury in that part?
Yes, sir, I can. The shot pellets, real close because they stayed together. They went in as one, as a unit, and then they did what a shot pellet does. They separate once they struck the skin and made entry. Run along inside his body cavity and exited his underarm. If his arms would have been up, he would have had no entry wounds on the bottom of his arm and then more exit wounds on the outside. He had over 20 entry and exit wounds, and he's only got 9 pellets. So the only way the math works out is if his arm was down. And additionally, the wad stopped and was under his arm. Had his arms been up, in my opinion, that wad would have went on and exited his body because it's only plastic. It doesn't take as much resistance to stop that wad as it does a shot pellet. And the wad stopped. It was right. You could grab it with your fingers if you would have been medical personnel and needed to. It was right there.
All right. And let me ask you this. Do you have a lot of general experience with firearms?
I do. I'm a firearms instructor for handguns, shotguns, patrol rifles, subguns, and fully automatic patrol rifles. Everything but precision rifles.
All right. And when you say an instructor, where is that?
I'm certified. I have credentials in the South Carolina Criminal Justice Academy. I've also been certified as an NRA law enforcement instructor, and I currently have a CWP endorsement to teach concealed weapon permits from the South Carolina Law Enforcement.
And you testified how many buckshot are typically in your average buckshot shell?
According to the literature and according to my experience, there are 9 in that particular buckshot.
Did you see any evidence? I think you've already mentioned this, but did you see any evidence from the crime scene as to what happened to some of those pellets as Paul was struck as they continued on?
Yes, sir, I did. They exited on through the back window.
All right. And I'm going to show what's already been admitted as 532 and put that up on the screen. And if you could describe to the jury what you're talking about in that regard, please.
This is that window at the back of the feed room, and you can see the shot shell pellet defects here as they went through the window and continued on their path.
Those kind of big holes, are those consistent, though, with buckshot pellets striking that?
Yes, sir, they are, and some are bigger than others because it's just the makeup of glass. I mean, sometimes you'll get one individual hole, and sometimes it'll take out, a large portion. So I have no way to know that.
All right. And just real quick, I've got 533. I'm going to put that up on the screen. And again, is that just a close-up of where Paul was standing about 5 feet or so inside that feed room?
It is, yes, sir.
Based on your review of the blood evidence that you saw?
Yes, sir. And here are the partial footwear impressions. And here you can see the 90-degree blood droplets and some other biological materials.
All right. And in your conclusion, what's the most likely explanation for those 90-degree blood drops? How does that physically happen?
It's the arm wound. Even though it was non-fatal, there's less restriction from clothing or anything else on the arm. Here you've got the t-shirt that's got to completely saturate before it gets to the bottom and drops. But here on the arm, you got nothing. So once those pellets exited, entered, and exited again, that blood's free pouring, or not free pouring, free running down his arm, and then they'll drip off the ends of your fingers.
One thing I want to ask you about is you've testified as to your conclusions as to the position of Paul when that first shot struck him. Is there anything about the entrance wound itself that supports your conclusion as to the shape of the entrance wound?
Yes, it's oblong instead of completely round. And had he been standing facing that door and took that double aught buckshot to the middle of the chest, I've seen it dozens and dozens of times. Instead of coming out this side, a shot shell or a projectile doesn't make a 90-degree right. Generally, it's going to follow the same path unless it hits something hard enough to make it ricochet. It would have went on through his body. It still would have exited the window. It just wouldn't have done the damage to his arm and his underarm. So he had to be canted in this direction. And the wound is not perfectly circular. It's more oblong, which tells you that he was canted to some degree.
All right. In your review of the crime scene evidence, did you come to any conclusion about the location of the shooter when that first buckshot blast struck Paul in his chest?
It would be hard to say exact, but I can say to a bare minimum, the breech of the shotgun, because I don't have the shotgun. I don't know the length of the barrel, that kind of thing, or I can run it from the door. But the breech of the shotgun, where it ejects the shot shell casing after it fires, was somewhere inside the door. Because had it been on the other side of the door, the shot shell would have been located outside. So depending on the length of the shotgun, at least I can say the ejection port was inside the door of the shell.
Right. And then the shooter, I have this image up here, which I apologize, is Snakes 534. And can you kind of illustrate what you're talking about to the jury using that image?
Yes, sir. The breech, the ejection port, where you load and unload that shotgun, which is a little less than midpoint from the shooter, was inside this door frame, at least to some degree inside.
And where were the expended shot shells found on this crime scene?
According to the photographs and the original crime scene, behind this door.
And is that consistent with your review of the evidence? Does that support your review of the evidence that you just, that conclusion you just related to the jury?
Very easily. If you look, this room was kind of cluttered, and I measured that door myself. It had been pressure washed, but the same door found the same shot shell pellet defects in that door. 1.5 inches at the bottom of the door, that's plenty of room for a shot shell to bounce and roll under the door. So I have no reason to believe it didn't end up there because of the location of the shooting.
All right. Let me get a couple other things marked. You can kind of head back to your home base, and let me just get these marked real quick. Dr. Kinsey, I'm going to show you what's been marked as 535, 536, 537, and 538 state's exhibits, and see if you generally recognize those images.
Yes, sir, I do.
All right, and generally explain to the jury what these images are, and then we'll talk about them specifically.
Those are images at the door that I've added some visual enhancements to help the reader understand the flight path of the second shot and the different elements that I looked at in determining where the shooter was for the second or the fatal shot to Paul.
All right, Your Honor, this time I'd offer states 535, 536, 537, and 538 in evidence. I believe without objection.
No objection.
Admitted.
All right, let's look first at 535, and before we get to that, generally describe again to the jury your conclusion as to that second injury suffered by Paul, the fatal shot as you've described it.
Well, the first thing is, once Paul received that second shot, he never walked again. He never made any movement. Any movement he made was involuntary, and it was due to gravity, pulling his body down to the ground. When you sustain an injury to your brain like that, that ceases all movement. So he was found outside the feed door. He fell over forward after sustaining that movement. Some wounds are fatal later. You can actually see someone that receives a fatal wound, and I've seen them run 100 yards. They can move for a little while. This is not that type of wound. Once he received this wound, it ceased all movement.
And did you, I'm going to put attachment, states 535 up on the screen, and tell the jury what this particular image reflects, please.
Yes, sir. If you can look at the green funnel that I've added just visually, if you look at that green funnel, that is approximately the shot shell path, the shot path from the shot shell after it did the injuries to Paul, or the direction of the shot from the shot shell. And I determined that by shot shell pellet defects that are still in the door, even though the door had been cleaned. I went and looked at it myself, run my own measurements, took the width of the door. I took Paul's approximate height. It's listed as several different things. DMV shows him at 5'6". The pathologist listed him, I believe, at 5'9". So I had to split the difference. I went somewhere in the middle. Then I deducted the distance between the top of your head and the top of your shoulder. So I took another foot off. Then I took the width of the door, and it's one other thing I looked at, and that was a void pattern that's on the door frame of the door. A void pattern is caused by something being there when the blood and biological materials are let. We call it a bloodletting from the wound, and there's a void pattern, which tells me something was in that way, and because of the narrow door, in my opinion, it was Paul. So that's what caused that void pattern on that door. So I used all of that, and I used a dowel rod, and I used a protractor on the doorknob side of that door frame, and I ran it up, and that's what helped me establish the angle of that shot pattern.
All right, and we're going to use the images to kind of talk about that a little bit more specifically, but quickly I want to show you 539 and 540 and see if you recognize these images.
Yes, sir, I do. 540 is my photograph when I visited the scene, and 539 is also my photograph, and it shows that top hinge of that door is approximately 72 inches at the top of the hinge.
All right, Your Honor, this time I'd move into evidence without objection, states 539 and 540.
Okay.
Admit it.
All right, let's, if you could, I'd ask you to step down again. I know I just sent you back there, but come on down. We'll put 539 up on the screen, and if you could. Tell me what this image reflects, if you would, please.
Yes, sir. These are 36-inch standard yellow yardsticks. We use them to measure certain things, and it right here is the top of the top hinge. It's a 3-hinge door, and this is the top of the hinge. And then 4 inches above this are where those shot pellet defects were that I used to figure out my angle.
All right, and looking at 540, who took this particular image?
I took this image.
So this would have been long after the actual event occurred. Is that correct?
This was last December. Yes, sir.
All right, and tell the jury what this image reflects.
You can still see the pellet defects in the door, and this is the approximate center of it here. So that's 4 inches above 72. That's approximately 76 inches on an 8-inch door.
I'm going to show you states 536 and explain to the jury what this is, and in particular how that's relevant to your conclusion about the angle in which Paul suffered the fatal head wound.
This is the original crime scene pictures. And this is where the pellets took their path. This is where they struck and did damage to the door. And you can actually still see the dents that are documented in my photograph. You can see them in the original crime scene. This is a concentration of blood that's caused by the brain exiting Paul's body in the path of the shot shells. And then you also have biological material, hair and blood, here at the top of the door frame. And that's where I drew my conclusion. At some time, those body parts made contact with these sections of the door. And my opinion is that it hit here, and then landed on the sidewalk.
Looking at States 537, can you explain what the jury's seeing in this image and how it relates to your opinion about the manner in which Paul suffered that fatal wound?
I can. With a major bloodletting,
Dr.
especially.
Kinsey, let me ask you, I'm gonna move this podium and ask you to step back just a hair so that the jurors over here can see what you're saying.
Yes, sir. With a shotgun wound, you've got not hundreds, you've got over 800 pellets that are making damage. It's not like a projectile, a single projectile from a pistol or a rifle. So there's mass damage, and it throws body fluids and blood in several different directions, but they follow the path. When I mentioned that it was a void pattern, this is the last blood drop. You can see it in the photograph that I can see, and it's approximately 5 foot right there. And this is not being taped. That is a digital effect I put on the photograph to show the void I was talking about. So it's my opinion that Paul was up against that door or real close to that door to keep that blood from striking the door at the point in time that he was shot.
Right, and the green tape reflects that blood path or that void area that is consistent with Paul blocking that area. Is that correct?
Yes, sir. Digital tape. It's not really tape.
All right.
Yes, sir.
So that's been added to.
Yes, sir.
Okay. To illustrate your opinion.
Yes, sir.
All right. And then 538, I'm going to show you this image. And again, if you can point out what's been added and how this relates to the conclusion that you're offering to the jury.
Yes, sir. One thing that I looked at to determine that it happened in the doorway and a little bit outside the doorway, more outside than inside, you don't just look for the presence of biological material in blood. You look for the absence of biological material in blood. Here at the top, it didn't have a scale or a ruler, so I can't tell you exactly, but looking at some of these other objects, I was able to scale it approximately 4 inches up here. You have a void. So I know that it happened, the second wound happened far enough outside of that door frame that the actual frame kept the biological material from hitting at the very top, right here. I also looked at these items. You got some medication, canine medication, or some cleaning materials and that kind of thing up here. You can see all the spatter at the front of those containers. And then we got what I call a demarcation line right here, and I drew it through most of these cans. And that separates the blood contaminated area and the clean area. So that tells me that it was at least forward of the angle on those containers. And that's why I believe he was shot. The second wound happened just outside the door frame, but his feet were probably still in the door frame.
All right, and just quickly point to the jury, can we see part of the door frame in this particular image?
You can, yes, sir, right here.
All right. Once, and going back now to States 535, and just for the record, we were just looking at States 538 and 537. Going back to States 535, did you reach a conclusion as to the location of the shooter on that second fatal shot that Paul suffered to his head?
Yes, sir, I did.
All right, and explain that to the jury if you would, please.
The shooter was right here. If you're facing that door, to the right of the doorway, outside.
And would you have expected there to be, in that particular range, any sort of biological evidence in that area in proximity to the shooter?
Yes, sir, I would.
Would the door frame have potentially blocked any of that as well?
It would block some, and just depending on the positioning, how much of the body of the shooter was exposed. Because, once you have that kind of catastrophic injury, it's real fine blood particles and biological fluids that go in all directions. And the closer the shooter was to the muzzle, to the exit end of that firearm, the more stuff you would expect.
Let me ask you this. In your expert opinion, is there any way that Paul's fatal head injury came from the top in a contact fashion or a close fashion?
No, sir. I see no possible way for that.
And explain your conclusion in that regard to the jury, please. What factors weigh against that in your expert opinion?
Well, number one, I don't know of a way to mimic this blood evidence on this door, that pattern where that shot traveled through Paul's shoulder, into his jaw, into his brain, and then took a path up and placed the biological material here at the top of the door. If he was shot in the head, then you'd have biological material out here on the ground, or at least going down, on the sidewalk in front of him. And it would be different than just free pouring blood. You would see this pattern, and you would see those high velocity blood droplets there on the ground. And plus the shooter would have to be on the roof to shoot down into him, but you wouldn't have this on the door.
In your expert opinion, did you see any support or evidence in this crime scene that could support that the injuries suffered by Paul were in any manner a suicide or self-inflicted?
I don't see the possibility, knowing that it's not a contact shotgun wound, and I'm fairly strong, and I'm bigger than Paul was, and I don't know of any way you could hold that shotgun out and shoot yourself in that direction at that angle and put that biological material on top of that door like that. I don't think it's possible.
All right, thank you. All right, I hate to keep sending you back and forth, but I'm going to send you back one more time. Now, let me ask you this. Excuse me. The second wound, the fatal wound that Paul suffered to his head, was that buckshot or was that birdshot?
The second wound was birdshot.
All right. And can you describe to the jury the difference between the composition of a buckshot round as it relates to the pellets and a birdshot round?
Yes, sir, I can.
All right, please do that.
With buckshot, you've got a number of larger pellets, approximately 30, 36 caliber pellets, and you've got fewer of them. They're made for bringing down larger game. So in the typical double-aught buckshot, you're going to have 9 pellets. In your typical number 2, and it's called many things, you know, the typical person calls it birdshot, chill shot, steel shot, coated shot. I've heard it called many things, so I just typically call it birdshot. But in this particular shot, there's approximately 150 to 156 pellets in that dry lock shot shell. So that's the difference. With the buckshot, you've got fewer and they're larger, and with the birdshot, you've got many and they're greater. They're for bringing down winged animals, squirrels, rabbits, dove, quail, turkey, duck. I mean, just depending on the number shot, that's what that's for.
All right. And about how many approximately birdshot might be in an average shotgun shell?
The literature says that it's 156 in a dry lock. I cut one open and only counted 150, but that may have been human error.
Around 150.
Yes, sir.
In your expert opinion, when you have birdshot, is there a forensic value to collecting every single pellet, or can you explain those concepts to the jury when you're dealing with birdshot?
I always try to collect enough that the firearms examiner can weigh it, and he can have a good representative sample of what was used to cause this injury. With a projectile or a bullet, you have what's called lands and grooves, markings, rifling. Some people call it rifling, and it's caused from that projectile spinning as it goes down the barrel. You don't have that in a shotgun. And a pellet is so small that you probably couldn't find it if you could have it in a shotgun. So in my opinion, there's no forensic value as long as you have enough to determine what type of shot or what type of shell and the weight of it.
In your opinion, and you've talked about this, but was the shooter, when that fatal shot was fired, inside or outside of that door frame?
The second shot?
The second shot.
Yes, sir. It was outside the door frame.
All right. And where was that second shot shell located?
It was also located under the door.
All right. And is that still consistent with your opinion?
Absolutely.
And can you explain that to the jury, please?
Yes, sir. Like I mentioned earlier, the ejection port on a shotgun, typically, and there are left-handed shotguns, but typically the majority of shotguns, the ejection port is on the right side. So as long as that shooter had it at an angle and had that ejection port pointed toward the door, even just at least a little bit, that would give plenty of opportunity for that shot shell to be ejected and go inside that door.
All right. I know I just sent you back. I'm going to bring you back down. I'm sorry. Before we move on from Paul, I would, and if you could just use me as a mannequin, but can you sort of describe to me your conclusions about the positioning of Paul when he suffered that fatal head wound and just how the trajectory of that wound and that shot as you've described and as supported by the evidence as you see it?
Can I describe it and demonstrate?
Yes, please.
So the jurors can see. The second wound, as I mentioned, went in his arm and caused an injury here, a large entrance, and then, of course, exit here. So it had to be typically with the kind of non-fatal wound Paul suffered to his chest and his arm. It's my belief that now his 5'8" frame is dipping or favoring that arm because, as you know, that's over 20-something entrances and exits. I believe it would have hurt him. I believe he would have been in pain, and I believe he would have been somewhat affected. And the reason I believe that is because I've got the 90-degree blood drops moving really, really slow. If he wasn't feeling it, or if it hadn't affected him in some way, I believe his youthfulness would have allowed him to get out of there faster. But he's moving real slow to the door. So that's going to drop that angle just a couple inches, and I can demonstrate now.
All right. If we can make sure that juror can see.
Yes, sir. Absolutely.
All right.
That wound went in approximately right here. It traveled in, out, in a straight line. In a straight line. Shot always goes in a straight line.
And then when you're pressing the dial stick there, you're showing the trajectory of the wound, not implying that was a contact wound.
No, sir, I'm not. I'm not implying it's contact. I'm just showing the level of the wound.
All right. While I'm thinking about it, the wound to Paul's chest, did it show evidence of stippling?
Yes, sir.
All right. Just very quickly, what's stippling?
Commonly referred to as tattooing. It's particles and material that's in that shell that don't burn up because it's superheated at the time that the powder charge ignites. It doesn't explode. It ignites and burns rapidly. And that's unburnt particles of powder and other contents of that shell. They're hot. And when they hit the body, they call stippling, or in the old days, they called it tattooing. And that's basically what it is. It works as an ink.
Looking at this particular image, Paul's about 5 feet in the feed room when he suffers the first wound, correct?
Yes, sir. That is correct.
And then he moves towards the door. Is that correct?
That is correct.
And suffers the second wound somewhere near the door frame on the inside.
Yes, sir. With his shoulder just outside that door frame.
And when he suffers that second wound, what happens to Paul?
He falls immediately.
And where does he fall?
He falls outside the feed room.
All right. Let's move on now and let's talk a little bit, if we can, about the injuries to Maggie Murdaugh. If you could start out by reminding the jury of the injuries that she suffered, and then let's talk about your conclusions as to the manner and the order in which those were suffered.
Yes, sir.
All right. So if you could just remind us again of those injuries, and if you could go ahead and describe them in the order that your expert opinion they were suffered.
Yes, sir. Miss Maggie Murdaugh suffered 3 non-fatal injuries from a firearm. One was through her wrist. One was her left upper thigh above the knee. One was at her abdomen here, and it exited somewhere around her kidneys. Now, I'm not that kind of doctor. I can't tell you all the damage it did inside, all those organs and things, but it ran a straight line through her body. This one on her left leg and this one on her midsection were approximately the same angle, and they were really, really close in distance. One had stippling that said that it was a foot closer than the other, but that would probably fit. This was either a total separate non-fatal wound, or it could have been a continuation of one of the 2 fatal wounds. Her fatal wounds were, she had an abrasion or a burn on the left side of her abdomen from the outside in. That bullet followed a straight path. It entered the end of her breast and did extensive damage to the end of her breast, entered her left jaw, side of her face area, and went into her brain. That's the first fatal injury. And it was immediate, and she dropped right where she was at. I saw no evidence that her body had been manipulated, moved, or rolled over. The second fatal injury was down into her head, and it actually did what in the day they call a keyhole injury just from appearances. The entrance and exit in the top of her head were so close, it made one big injury, and then it entered into her upper shoulders and went down into her body. That would have also been a fatal wound, but it was second. In my opinion, that one came second.
All right, let's talk about that in a little bit more detail. Those first 2 wounds that you described, do you believe those are the first 2 wounds she suffered?
Yes, sir, and possibly 3. I can't tell you much about this because the arm could have been moving or it could have been here.
All right, well, let's talk about the thigh wound and the abdomen wound. Did you have any conclusions about the location of the shooter as those 2 wounds were suffered?
Yes, sir, I did.
All right, explain that to the jury, please.
Right there. All right. Left leg out a little bit. About here and here. Here and here.
And in your opinion, were those 2 shots fired in fairly quick succession or around the same time?
I think it would have been really, really difficult to get a similar angle if they weren't. All the shooter had to do is raise the weapon or lower the weapon, and you're still on the same plane.
And did those wounds to the abdomen and to the thigh reflect the presence of stippling?
They did.
And what does that indicate to you about the distance between Maggie and the shooter when those wounds were suffered?
I guess 4 or 5 feet.
Fairly close?
Yes, sir.
All right. And after those 2 wounds were suffered, and again, we'll put aside the wrist wound for a bit, what would have happened after that in your expert opinion?
In my opinion, at bare minimum, she would have been over. She would have been in pain. I believe sometime in close proximity, she fell to the ground, and that's when the first fatal wound was delivered.
Would she have been prone on the ground or still somewhat raised above the ground or in a bent over position when that first fatal wound was suffered?
In my opinion, from the angle, she would have been on her knees and had at least one hand on the ground.
Those first 2 shots, well, let me ask you this. There were obviously 6 shell cases of 300 blackout that were used to murder Maggie Murdaugh found at the scene. Is that correct?
That is correct.
Explain to the jury, what conclusions, if any, can you draw about the location of those shell cases, if any? Explain that to the jury a little bit.
Once again, just like with the shotgun, I'm not saying it doesn't exist, but I don't think there are many left-handed AR platforms. So generally speaking, the ejection ports will be on the right side. I own 7. Some of them throw it, the shell casing a little bit forward. Some throw it a little bit back. Some throw it perfect 90 degrees to the ejection port. If they were always uniform where they come out, if you go target practice, you could place a bucket there and all your shell casings would drop in the bucket. You wouldn't have to bend over and pick up your shell cases. Unfortunately, that's not the real world. So I don't put a lot into that unless I have the actual weapon and we can test the weapon with the same ammunition and you can generally get an idea where that shell case is going to go. So no, sir, I don't pay a lot of attention to it. And I definitely don't think the sequence of from one end to the other or from this end to this end means that's necessarily the movement of the shooter.
All right. You said that when she suffered that first fatal wound, in your opinion, I mean, she would have been over and perhaps been on her hands and knees. Is that correct?
Yes, sir.
All right. I'm going to get down on my hands and knees. And if you come around here and kind of show me where the trajectory of that wound would have gone, the first wound that was fatal for Maggie Murdaugh. I guess you can come around me. Yes, sir. All right.
Right. The shooter was right here, approximately right here.
All right. And show us the trajectory as it went through Maggie into her brain.
Yes. It burnt or grazed her stomach outside to inside, went through the end of her breast, into her jaw, and then into her brain.
Okay. And what would have been the effect on her once that shot was suffered?
She would have immediately fell down with the front of her body.
All right.
And that is the position her arms were in the original crime scene photograph.
And while I'm down here, so I don't have to get up again, tell me about the fatal shot and the position of the shooter as the evidence indicates to you.
The second shot was not as close, but it still wasn't a long distance. It was approximately here into the crown of the head.
And use the dial stick to show that injury that Maggie suffered.
In, out, in that line.
Thank you. We go drop in after this. All right. The first shot, the first fatal shot, that would have immediately been fatal. Is that correct?
Yes, sir.
The second shot also would have been fatal had she still been living, but in your opinion, she was not at that point. Is that correct?
Yes, sir.
All right.
She may have had a sign of life, but there was no movement. She was not capable of any movement at that time.
All right. Go ahead and have a seat for me. Of course, as soon as I say that to you, I'm probably going to have to put that out. Let me talk about something else real quick before we come back to this. I'm going to show you what's been marked as States 541 and see if you recognize this document. I'll bring it back to you. Good, hold on.
Yes, sir, I do.
All right, tell the jury generally what this document is, please.
That is a comparison and presentation that I put together over an unidentified impression on Miss Maggie Murdaugh's left calf.
Your Honor, this time I would move States 541 into evidence under seal.
Okay.
Submitted without objection.
If we could make sure the monitors are secured, please. All right, I'm gonna, are all the monitors secured? We're good? I'm gonna put Stage 541 up on the screen. I'm sorry. I got thumbs up before taking, correct? All right. Moving 541 and putting it up on the screen. If you could tell me, first of all, what do we see here before we get to your analysis on this particular issue?
This is a general photograph of an impression on Miss Maggie Murdaugh's left calf.
Okay. And do we also see a wound on this picture?
You can see the exit wound from that thigh wound that I described earlier.
All right. And what, if anything, did you notice about or conclude from the sort of blood pattern on the back of her thigh there?
She stood a little while. I can't tell you how much time, just like with Paul, but she was standing after she suffered that thigh wound because the blood is running down the leg and gravity always pulls it to the earth.
All right. And then, I sent you back there. I'm going to just bring you back on down. I'm sorry about that. Bring mistake. If you would, and again, make sure you're out of the way of the jurors. Was there any sort of mark or any sort of mud mark on the back of her leg?
Yes, sir, it was.
All right. And point that out to the jury, please.
Right here, an unknown impression on her leg.
Okay. And did you engage in an analysis of that particular impression?
I did, yes, sir.
All right. You just stay there. I think it's probably easier than sending you back. I'm going to move to the next slide. And just tell me what this is, if you would, please.
That is the same impression, unknown impression. I've just cropped everything out so you can concentrate on the actual impression.
All right. Moving on to the third page of this exhibit. What is this?
This is a side-by-side all-terrain vehicle that was in close proximity to Miss Maggie Murdaugh's body, where her final spot where they located her, and this is in close proximity to where she was located.
All right, stand by for me real quick. I'm going to show you what's previously been admitted into evidence as State 70 and State 71. And can you tell me what these images reflect?
That is that Polaris ATV side-by-side that I mentioned.
All right, and generally remind the jury where this was located.
Miss Murdaugh was laying face down. That was to her left, underneath a overhang or a I don't know what you call it, a shed that was attached to that airplane hangar. A lean-to. That's the word I was trying to think of.
All right. And do you see any indication of any biological material in the crime scene images that were taken at that Polaris?
That was my first indicator. That's what made me concentrate on a specific tire. Yes, sir.
Okay. Let me see how washed out that is, if I can maybe fix it. And can you point out an example of what you're talking about on that image?
Yes, sir, I can.
And I can bring you the original image if that's better.
Right here, we got some kind of biological material, and I'll tell you the reason I believe that to be so. Like I said, blood has a viscosity or a cohesive factor to it. That's why a blood drop stays together. You know, if you throw a drop of water on a tire, what's going to happen? It's going to run down. But here, and actually here on the front of that four-wheeler, in my opinion, that's some type of biological material.
All right. I'm going to do one other thing. Let me slide by you real quick. All right, looking now at defense 29. Again, if you could, just this is the feed room right here, is that right?
Yes, sir.
And just if you could, just point to the general location of this ATV and where it was located in the crime scene.
Yes, sir. Yes, sir. Right here in this area.
All right, and that would be, again, on this is not to scale, but that would be at least on this diagram where Maggie was, is that correct?
Yes, sir. That's our approximate location.
All right. Looking at going back to this particular slide and your analysis of this tire, if you would explain a little bit about what you see here and what an examiner looks at and looking at sort of this particular tire as it relates to your analysis.
Yes, sir. What we look at as footwear and tire tread or tire track examiners, we look at the actual tread pattern and design of that tire or that shoe. And there are a couple different conclusions you can come up with. We compare known and unknown. It's not like you see on TV where you take a picture of a shoe and feed it into a computer. Some people have footwear databases, but it still has to be examined by a human. There's no magic machine. If it is, I've never seen it. What we look at the dimensions of the tread pattern. We look at the shape, the sole, the outsole design, the tread design, the measurements, and we try to find class characteristics. That's shape, size, sometimes depth, or the physical properties included in that pattern. And then to make a complete identification, that's a class characteristic. That's saying there's an association, either this shoe or this tire could have made this unknown impression, or another one just like it could have made this unknown impression. So that's a class or an association. Then you got an identification. That's where you say, to the exclusion of all others, this shoe or this tire made this print. Now, to make an actual complete identification to the exclusion of all others, you've either got to have what's called a random unique characteristic, a thumbtack in the bottom of someone's shoe, bubble gum, damage to the tread pattern on that tire. You know, you hit something and it cut a tread pattern. So that's pretty difficult unless you have the actual tire, the actual shoe, and then you take it and compare it to the unknown. And what you'll do is take that tire and three-dimensional comparisons are always better than two-dimensional. Two-dimensional is a photograph. You can't tell depth. You have to have the actual cast of that footprint or that tire. Now you've got three-dimensional. You've got the width, the length, and the depth. So it's a little bit better to have a three-dimensional to compare with, but you can do a lot with a two-dimensional. If you can get it scaled to the size, you can associate it with another thing. You're looking for them unique random characteristics. They call them accidentals. It's something that happens by accident, just because of the way you walk, the way you drive, what you might hit. And that's what you look at when you do a tire or footwear impression analysis.
I'm going to move on now to the next page and your exhibit, and tell the jury what these two images are, please.
Yes, sir. This is the unknown impression on Miss Maggie Murdaugh's left calf, and this is the photograph of the known front driver's side tire of that side-by-side.
All right, and when you were starting to compare these two, did you have to make any account for the relationship of Maggie's thigh and this ATV tire?
I did.
Explain that to the jury, please.
Just like if you're driving in your car and an ambulance comes up behind you and you look in the rear view mirror, you can read ambulance. But if you look at the front of that ambulance, it's written backwards because you're looking through a mirror. Well, with a shoe, a tire, or Miss Maggie Murdaugh's leg, you can't see through her leg. You can't see through the tire. So you have to flip one of them or the other. So flipping the tire, in my opinion, because it has some characteristics on it that I wanted the reader to be able to look at, I chose to flip the impression on her leg to do the comparison. Because unless you do footwear and tire tread examinations, you're not going to be able to look at something in reverse and find those points.
So this is the original orientation, is that correct?
It is, yes, sir.
And then flipping over to your next slide, that's where you've reversed the image, is that correct?
Same photograph. I just pulled it over. In the old days with 35 millimeter film, and I'm from the old days, we just flipped the negative. That's all you had to do. It's a little bit more complicated in the digital world, but not that hard to do. But this is a direct representation. It's just in reverse.
All right. Continuing on as we go through your analysis, what does this reflect?
This is just a side-by-side so you can understand the orientation here, 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 and here. Those are the two treads that we're talking about now.
All right.
And by the way, those on the tire are the only treads at that level on her calf that I believe needed to be examined.
All right. And again, these are just additional images illustrating what you were focusing on in your analysis?
Yes, sir.
Okay. And then this one right here?
Yes, sir. That's a side-by-side view once again, with all the background cut out of it.
All right. And then the final one is this. Explain this to the jury and how this supports opinion.
This is my actual comparison and a process called ACE-V, where you analyze, compare, evaluate, and verify. It's a peer-reviewed process. I never go by just my results. I always have another competent examiner with like experience and like skills look at my work, because if you're going to make a mistake, that's where the mistake's found. You don't want to put a conclusion out for something important and you miss that. And that is a very important process in the examination world, that you use peer-reviewed process. You have someone else look at it. And so what I do, so that person and the jury in the court, Your Honor, so that person can look at these details. I've got a markup here showing some unique random characteristics that I've used, but I also put the actual impression there so you can make your own decision. I didn't want to look like I was being deceptive and put enhancements in there and point things. You can look at it and make your own conclusion. But I wanted to put it right next to mine so you know I'm being straight here, or you can make your own opinion.
All right, very quickly, is it your expert opinion that this mark on the back of Maggie's leg is a tire impression and not anything else?
That is a tire tread impression. That is my opinion.
All right, now I see you have a number of arrows here that have different colors, and so I'd like to move through those and you explain what you're pointing to with those arrows in this image, okay?
Absolutely.
Let's start with the baby blue one and tell the jury what that indicates to you.
Now, you're going to have to tell me because I can't tell shade from up here.
Right.
Okay, the top one.
Yep.
Yes, sir. All right, here you got your unknown impression. You see that there? Here you got your unknown impression. And what I pointed here is at the start of that impression, and it's in mud, by the way. It's in mud, and so it's really, really fragile, but it's still here. You got an unknown impression, and here's approximately where it starts in the unknown, and here is where it starts in the known. And you can look at both, the marked up one and the actual impression itself.
Right.
And it's here.
All right, and then moving on to this one right here, kind of we got a purple one, and then kind of that
Yes, sir. I see
whatever that one is. But explain
Yes,
to the jury what you're seeing there and how that supports your conclusion.
Right here is the other side of that tread. And this tread is this tread is this tread. Those two are the same. And right here, you can see it come up, and it actually makes a complete corner there. Comes up, and it curves out just a little bit there.
All right, and is that consistent with the sort of unique shape of that top tire?
Yes, sir, it is. Right here, and then it comes up. Now, it's exaggerated a little bit in the drawing, but that's the best I could do with a stylist trying to get it there.
Are those very distinct patterns that you see in the mud that match up with that particular tire?
Yes, sir. Not so much the corner there, but these in here are. You can see a unique random characteristic here, and all that is a void pattern in the mud. You can also see it here. I mean, almost perfect. You can see one here where the yellow area is. You can see it here. It's right there.
All right, you're kind of doing a little mountain or a little hump. Explain that to the jury. Why is that particular? Why is that significant to you?
Because that's not in the process of making the tire. That's because whoever drove that side by side last hit some dirt or some mud, and that is a pattern that's left in mud on the tire. And in my opinion, it transferred to Miss Maggie Murdaugh's calf.
All right, and show the jury where you're talking about the little hump on
Yes,
this
sir.
image right here. If you can show it.
It's marked with a yellow arrow, and here it is, right here. I've marked it there, but you can look at the one that's not marked, and you can also see it here.
All right, talking about this bottom impression, we got a white arrow to that line right there. Explain that to the jury. What's significant in your analysis of it?
I marked that because unless you examine, unless you got really, really good eyesight, you might not even pick up on that. But here you've only got a partial line. The whole line didn't show through in the transfer of the mud or dirt or debris. And I kept myself honest. I only highlighted the length of that, but you can also see it here and here. You can see that side of that tread, that tire tread.
All right, and moving on now to the this green one right here, and kind of green to the baby blue to that blue, just kind of going around there. If you could explain that to the jury and its significance, if any, to your analysis.
It's just a continuation, and there's a little break in there, but they're still the same angle, same lines, and they match up, and that's just because the dirt didn't transfer completely. But you got plenty of skeletonized line here to show the outline of that tread here, here, and here, and that's here, here, and here.
In your opinion, that's a tire impression, is that
That is
correct?
a tire impression. That's my opinion.
And in your opinion, based on these very significant mirror images and accidentals and that sort of thing, is that most likely that specific tire tread that's on the back of
It is most likely that tire. If it's not that tire, it's a similar tire with the same tread design.
And that particular tire was in close proximity to where Maggie was found.
In close proximity.
Looking at how you had Maggie in that first shot, I think you had me kind of angled a little bit like that. Is that correct?
Yes, sir.
And if she was angled that way near that front tire, would she be facing towards the feed room?
Yes, sir.
All right. And are those two shots that were suffered in the abdomen and the thigh, are those consistent with the shooter coming from the direction of the feed room? Those-
It could be. Yes, sir.
All right, go ahead and have a seat for me if you would. Sure, I'll have you back up. All right. Additionally, with this particular tire tread impression on the back of Maggie's calf, is that consistent with her running into it or backing up into it with her calf hitting that tire as part of it?
Leading, I've not, this is my first leading objection on this, but I object leading.
I would say sure. All right. Let me ask you this: with this particular tire impression and what you see on Maggie's calf, is there a reasonable explanation as to how that impression got on her calf?
At some point in time, Miss Maggie Murdaugh's left calf made contact with the inside of that front driver's side tire, or one just like it, and I saw no evidence that she was run over. So she had to make contact at some point in time.
Gotcha. All right. Hold on for me 1 second. I've just got a few more matters. All right, I'm going to show you. Be careful. This one will be under seal. So can we secure the monitors, please? I'm gonna show you what's been marked as 542 and see if you recognize this image.
I do.
All right, and just generally tell the jury what that is.
It's a cell phone sitting up on the back right-hand side pocket of the victim, Paul Murdaugh.
All right. Your Honor, this time I move states 542 into evidence under seal.
It's admitted.
All right, are the monitors secured? I'm going to put this image up on the screen. All right, and again, is this your understanding of how Paul's phone was found at the crime scene?
It is.
All right. And did you make any assessment or analysis of whether or not Paul's phone could have popped out and be found in that position?
I did.
All right, and can you relate that to the jury, please?
It's my opinion that his phone was placed there by someone else.
All right, and tell the jury your basis for that conclusion, please.
Well, after I mentioned the fatality, the fatal shot, at that point in time, you have no movement, even involuntary movement, and there's no way Paul could have retrieved that phone from his pocket and placed it on top the back of his pants.
And in your opinion, if he had been carrying that in his hand, could it have landed in that fashion following the fatal shot he suffered to his head?
Mathematically, you could have made it happen, but I don't believe it's possible. I believe the phone would have fell to the ground and it wouldn't have fell behind him up in the air and landed on him.
A couple other things. You testified about your experience in crime scene and that sort of thing. Is that correct?
Yes, sir.
Is there any forensic value in a residence belonging to certain family members and doing any sort of DNA swabs of the bathroom sink or the shower drain or anything like that?
If it's an unknown person, maybe, but not if someone lives there. I see very little forensic value in that.
And why is that? Can you explain that to the jury?
Because we as humans, we swap, we lose biological material every day. We brush our teeth, or we should. We brush our teeth and we shampoo and we wash, and there's commonly blood and other bodily fluids in our drains, in our tub drains, and generally everywhere except in the toilet bowl. Generally, yes, sir, under black light.
You've talked about your experience and your certifications with firearms. Is that correct?
Yes, sir.
Do you own yourself any AR-style platform rifles?
I have 7 complete rifles, and I also own a couple strip lowers that I'm just holding for a rainy day.
Gotcha. And what are those chambered in?
223 556.
In the AR platform, is that the most common chambering for an AR platform?
I believe it is. Yes, sir.
Do you personally own a 300 blackout?
I do not, but I have trained and shot a 300 blackout.
And why do you have 223 instead of 300 blackout?
The cartridges were a little bit more difficult. Well, they were a lot more difficult to find during COVID, and they are a lot more expensive than 223 and 556.
300 blackout pretty loud?
I think they're all loud. Yes, sir. I have to wear hearing protection around my rifles.
300 blackout louder than a shotgun?
Absolutely. I don't wear hearing protection when I hunt. I'm an avid hunter, but I have to wear hearing protection with my rifle.
Hold on for me 1 second.
Ladies and gentlemen, I have to go to the jury room for a break. Please do not discuss the case.
If when you observe defensive wounds, what's called defensive wounds, you would see signs of a struggle. I saw none on Miss Maggie Murdaugh or Paul Murdaugh in any of the autopsy or crime scene photos.
Thank you. Please answer any questions the defense may have.
So do I call you doctor or deputy or chief or what?
I have been a deputy in about 25 years, Mr. Harpootlian, but I'll answer to whatever you call me, sir.
You may regret that. So, you've been, when did you start in law enforcement?
Around 93.
And you were in Northbrook?
Yes, sir.
You know, back then, I was a solicitor in the Fifth Circuit. I was a prosecutor then. Do you remember that?
I've testified for you a couple times.
I thought you looked familiar. So you actually were my witness a couple times.
Yes, sir.
Okay. And I don't know if we're going to have much to speak today, but I'm going to try to understand a couple things. That's okay with you?
Absolutely.
So let's understand the wound to Paul, the two wounds to Paul. And as I understand it, you were saying that he was standing how far back when he got shot, struck down? For his bloody footprints to be there, those footprints had to be made after he had the shot in the chest, correct?
That is correct. Yes, sir.
And so how far back in the room were those footprints?
The footprints are approximately, because I have no way, once everything was pressure washed and cleaned out, but looking at the actual crime scene photographs and then taking my own measurements, the placard, the yellow placard that's in the photographs is approximately at 5 foot. And he was on the other side so he was occupying that 6 foot area.
And there were no scales in any of those pictures, were there?
There were not, no, sir.
Let me just talk about this generally before we get to that. You teach a course on crime scene processing?
Yes, sir.
You teach a course on how one should photograph a crime scene?
Yes, I do.
And I'm going to try to oversimplify this. There's basically 2 or 3 things that you want on any crime scene photo. The first is a scale, correct?
Well, there's 3 types of photos. One of those includes a scale. Yes, sir.
Okay. I mean, obviously you don't have a scale. It's a long shot out, like from outside the feed room in. But for something like bloody footprints, you would want a scale.
I would. Yes, sir.
And you want multiple lighting sources so that it's well lit.
Well, if you operate the camera correctly, you have your light source. And that's why you do it from 90 degrees over perpendicular to the footprint, because you can hit all the angles and then choose the best exposure that takes those shadows out.
So if you do 90, do you recommend taking more than one shot?
Yes, sir. Typically.
I mean, at different perspectives of the same item?
Yes, sir.
Okay. So you recommend multiple shots, including one. Got to have one 90 degree.
If you're for comparison evidence, you do. Yes,
Right.
sir.
And in the sense of the shoes, the shoe prints you think that you saw, they were definitely Paul's shoes. You did that comparison.
Just like with the tire tread, they share class characteristics with Paul's shoes.
And were those shoes facing towards the front or the back of the feet?
When they were made, it appears they were going toward the door.
Right.
But it would be hard for me to tell you without some kind of mark on that pavement to be able to orient them.
I'm sorry, I couldn't hear that.
Without a mark on the pavement or some type of landmark, it would be hard for me to orient them from the photograph.
Okay. And again, if you had a scale or multiple pictures of that one shot, straight down and multiple pictures, you could have done a little bit more in terms of that, could you not?
An examiner possibly could have, yes, sir.
And the trail of blood leads towards the front door, right?
It does.
And how long was that trail?
Well, if he was in the 6 foot and you got 4 past him, at least 5 foot from where he starts dripping blood, then he steps in it and then he makes his way to the door.
So you think he was a foot and a half inside the door when he got shot with the second shot?
Well, his feet were inside the door, but his shoulder and his head was slightly outside the door.
Leaning forward?
Yes, sir.
Okay. So the first shot, as I understand it, hit his shoulder.
The second shot is the one that hit the shoulder.
No, I'm talking about, let's talk about
The fatal one.
the fatal.
Yes, sir.
It hits his shoulder.
Yes, sir.
So based on, now you met with Dr. Reamer, the pathologist,
I did.
and she showed you her photos. Y'all talk about her photos?
I offered to go over the photos with Dr. Reamer, and she told me that she had limited crime scene experience and that I'd have to determine that she looked at the wounds and she makes her determinations, and that wasn't really her forte.
Okay. So, but she said shot in the shoulder. I'm talking about the fatal shot.
The path, yes, sir.
Into the neck, out the top of the head.
That is correct.
Okay. So, and how, you said you had some difficulty determining Paul's height.
Well, the DMV record, the printout showed 5'6", and the autopsy information showed 5'9", and I know a young man like that will hit a growth spurt. That's not my area. So,
but would you consider Dr. Reamer's measurement probably more accurate than what he told the DMV?
or he could have grown since he registered with the DMV. Yes, sir.
So why wouldn't we just use 5'9"? Is that fair?
Well, but then he's got damage to the top of his head. So I asked myself, how could Dr. Reamer get it exactly right when the top portion of his head's gone? So I had to guesstimate, and I figured the best way to do it is split the two.
And the two were, so you had it at what height?
DMV showed 5'6" on the printout, and Dr. Reamer showed 5'9". So I figured somewhere around 5'7.5" to 5'8".
So 5'7.5".
And then you take the foot from there to the actual wound.
Right. I guess. So where the wound occurs, the initial I guess it's the shoulder.
Yes, sir.
How high was that?
That was approximately 4'7".
4'7".
Yes, sir.
Okay. So give me a second here. We're going to do it. I hadn't touched a protractor in 50 years. I've done it twice this week. So let's do, if you step down here for just a minute, please. Oh, you walk around with one?
Yes, sir.
Really sad. Really sad. So why don't you take this for me, and I'm going to hold it. I'll hold the bottom and put a dot on here at 4'7". shoulder, the height of the shoulder. Okay, I'm gonna take it straight. I'm gonna put it down there. Okay. Let me just get it up here to 4. Let me do this. I think you can do this one. 4 foot, 6. We're saying 4'7"?
Yes, sir.
You don't have a lot here. There's no. Okay, so that's 4'7", right?
Yes, sir.
Okay, let's go straight up. Okay, and that would have been the height of the window.
That's the height, approximate height of the shoulder, depending on how far he's getting.
I think it's lower.
Could be, yes, sir. Like I said, when you've got a wound to that side, I would expect him to be favoring that shoulder.
Okay, so what's your opinion of how, I mean, you're the professional engineer. Hold on.
Well, looking at the defects on this side of the door,
Yeah.
and it's several of them there, even though they've been pressure washed, if I run a string back in the area of 4'7", somewhere in the middle, gave me a 135-degree angle. That's give or take 5 or 6 degrees.
And that's what Dr. Reamer said in her report, 135 degrees.
I don't know if she said that for report, sir.
Okay, I'm fine.
Yes.
All right. I'll do that. Thanks. Give me 2 seconds and I'll go back first.
But that's not absolute. Like I said, a lot of variables could change that a couple of degrees somewhere.
Couple of degrees. Okay, sure. Make sure I have the right. So. So while I'm looking for this, was there any evidence of stippling, soot, powder burn, anything? Is soot the same thing as powder burn?
Soot is by product, yes, sir.
Okay. Around the
But
shoulder.
soot can wipe off. The powder burn, the stippling doesn't easily wipe off. It's actually testing.
And that would indicate a pretty close shot.
Yes, sir.
And you would agree, Dr. Reamer said there was no evidence of any of that, any stippling, anything to indicate it's a close-in shot.
That is accurate.
And she testified, I don't really saw her, did you see her testify?
A little bit of it. Okay.
She testified that the muzzle of the gun, the weapon, the shotgun, would have been at least 3 feet away, perhaps 4, but at least 3 feet away. Is that consistent with your experience?
I don't know if that's consistent with my experience. I'm not trying to disagree with the pathologist, but I don't see how the angle would work out unless it was a pretty short shotgun. I don't see that angle working out 3 feet away. It maybe have been within 3 foot.
What being, how far away was it? There was no, I mean, at what point?
Well, at the angle, the bullet defects would have been here at 76 inches.
Right.
So you've got quite a difference there. If I could get that dowel. You want to swap places with you?
Yeah, I'm trying to find that 135 degrees something by her, but
To make that axis,
yeah,
at 3 foot, we're here.
right.
At 2 foot, we're here. So I believe it would be more in line with 2 foot, but I'm not contradicting a pathologist.
Okay. I know it's in here. Give me 2 seconds. I thought I had it marked. Give me 1 more second here. Well, so assume that you said, and you relied on Dr. Reamer's 135-degree shot. Let's follow that down.
Now, Mr. Harpootlian, I reviewed her stuff, but I went and measured my own angle on that door. Now, I didn't rely on her angle.
Well, but she actually, you're going based on where those pellets were.
Yes, sir.
And she would be going on measurements on the shoulder.
Yes, sir.
And she's actually looking at the wound.
Yes, sir.
And she would have maybe a more accurate angle because she knows, she sees what the wound is.
She knows the angle to him,
Right.
but she can't relate that to the defect at the scene.
But do you think it's, I mean, 135 degrees is basically a 45-degree angle, correct?
Not quite, but yes, sir, close. Yes,
Okay.
yes, sir.
So it's 45 degrees off of that dot.
I did my measurement from a little bit lower on the door frame. I took my protractor and placed it on the door frame, inside the door frame. Like so.
So you don't think it's that tall? You think it's down?
Well, that's where his shoulder's at, but the angle of the gun, depending on the length of the barrel,
Right.
it would have to be here because it's not a contact wound. So it
Right.
would have to be down a little bit, but the angle doesn't change, just the distance changes.
Right, right. So, but, sorry, standing between. So, but if you come off of this 45 degrees, for the sake of argument.
Okay, for the sake of argument.
Okay, that would show you the angle of whatever hit his shoulder.
As long as the angle stays the same, yes, sir.
Okay. Well, the angle-
I've got it on 135, by the way.
135 would be 45 degrees off of straight up and down. So don't you have to take it over this way?
Well, you've got 90 in the middle. It depends on where your axis is. You've got 90 in the middle. This is 180. All the way around is 360. So here we've got 135 off the door.
Going that way. Can you make it go this way, please? I want the line not going this way. I want to be able to draw it out this way.
You just flip it,
There you go.
and you go above it.
Okay, would you do me a favor? And let me get a ruler for you. Can I have that long ruler, please? And let's take it. Just, I'll hold it. Like that. If you'll just get that. Okay. And so, and again, it could be somewhat lower if you turn.
Yes, sir.
But
And that would change the angle. That's why I said approximately 135. It could change it a little bit.
how much?
A few degrees. You know, as if you figure if this is 135 and if he's 2 inches lower, that would, you know, take probably 5 degrees off.
So that would be 130.
Maybe if you sit it up there, we'll measure it. I can take it for sure.
Okay. So, okay, what do you want me to do?
You hold the protractor up. There you go.
So we gotta go this way. No,
Okay. You got it.
there you go. If you want to go that way.
Which way you want to go?
I want
Flip it. Flip it. There you
Okay,
go.
there we go. You want this way? You're the.
No, I got a feeling you're familiar with me, Mr. Harper.
You got that feeling?
I got a feeling.
Okay. So that's 130.
Yes, sir.
What do you want to make it?
Well, I'm not measuring it this way. I mean, you tell me what you want me to make it because I measured it this angle.
Yeah, but this is just the flip side of that. Remember how you talked about the negative?
All right, put it back.
Okay. Which way you want it? This? That? Okay, that's 135. What do you want to make? Oh, wow. There you go.
All right, so if it was, let's say this end was down a little bit, that would make it what? Now you're on the bottom half now, so that changes it. Now we're at 40.
Yeah, well, that's 45.
Right.
Now it's 40.
Right.
See, I went to Clemson too.
Yeah.
And so, this is sad. So if you make it 40 instead of 45 degrees, what is it?
Here.
Okay, so. Okay, you want to draw that in? With the red pen right on the.
Nah, that's not intentional.
Okay, so those are basically, what you're saying is those are the two possible paths and then maybe one in the middle.
It could be. Yes, sir.
Now, and you believe that the shooter was how far away from him with that shotgun?
I think 3 foot is a stretch without having some damage to the door frame.
Right.
Because that shot pellets immediately when they leave the barrel of that gun at 3 foot, that shot pellet's going to spread 1 inch. There's no damage to the outside of that door frame.
Why would there be?
Why would there be what?
If it's spread, how far, 1 inch?
If his shoulder is barely reaching that door frame, and that's what the blood evidence tells me.
Right.
If you are further back, them shot pellets are going to do what they're supposed to do. They're going to open up, and there's no shot damage to that door frame.
Okay.
So,
You recognize it?
yes, sir, from photograph.
And it's a Benelli shotgun, is that right?
Yes, sir, it is.
Okay, so,
I prefer to come close. I have some. I have some.
I like this one. Let me take it here. Okay, if you take that shotgun and, I like these boys back here, I don't mind if you point it in my direction. Okay, so if you take that, the muzzle of that gun and follow the line down, please. And let me turn this just a little bit so that you're back here can see. Okay, follow this down, either one of those down. So that would be the position the shooter had?
That's the angle. I mean, I'm on the opposite side, you know, of where the shot came from, and I don't know the length of the barrel, but that would be the angle.
If I'm standing, I'm calling it, I'm standing in the door, why is that the opposite side? Bent down a little bit. I don't understand what you mean by the opposite side.
The shot came from over here. It didn't come
Well, this is
from.
a two-dimensional representation of a three-dimensional, but I'm trying to figure out just the angle from the muzzle.
All right, if you're coming out of the door,
Right.
and you got damage to your right shoulder.
Right.
Instead of your left shoulder.
Same.
All right, turn this way.
Okay,
And that is the door frame
right,
with here.
right. But, and that distance there is how far from the barrel?
2.5 to 3 foot.
That's not true, just to be. So actually, that is,
I'm going to your shoulder now.
okay.
You got to turn. You got to turn. Yeah.
Okay. So that is about 24 inches.
Well, you step closer, but yes, sir, about 24 inches.
Again, we both want the question. Okay, so this is getting complicated. So what you're saying is whoever shot him was holding the shotgun that low?
Really low. Yes, sir. Not from the shoulder. From some position other than the shoulder.
Why? Would it be easier just to go boom, right in the head?
Sir, I can't figure out why people do what they do.
But I guess, okay, so the person with the shotgun has just shot him in the chest, and he would have been turned to the left. And that's what gone through under his armpit, out the window.
Right.
Okay, and then he shuffles over to right at that position.
Toward the door.
Towards the door. And then whoever just shot him, you would agree with me, the first shot was inside the, the shooter would have been inside the feed room for shot number
At
one.
least to here. If this is the door frame,
Right.
the ejection port of that shotgun was in at least this far.
And how far back was he in the room when he got shot?
Paul?
Yeah.
Just on the other side of the 5 foot mark.
Okay, so how far was it from that 5 foot mark to the door frame?
5 foot.
Yeah, no, I mean, how far would the barrel have been if that was just inside?
Well, it depends on the length of the shotgun.
Assume that's Benelli, whatever.
Well, if this represents 5 foot,
Right.
and I've got the ejection port inside the door, what, 2 foot? I mean, you don't know, 2 foot maybe?
It's going to move this way, but even to me, I can't do. Thank you. So this is 5 feet, right?
I don't know if this is the door.
This is actually 6 feet.
So if it's-
that might be-
For demonstrative purposes, if it's this gun, and that reaches inside, so that's what, how far? I can see.
I'm at 5 feet.
Okay, and step just a little bit behind 5 foot,
Okay.
as he's occupying that next foot. There you go. So how far is that?
This is 5 feet.
Okay.
This is a little bit back,
Yes,
5
sir.
feet.
Now, hands your body,
This way,
Yes, sir.
this way, okay. What do you mean? Turn my feet?
Yes, sir.
Okay,
a little bit more,
Okay.
right there.
okay. Now, and you're shooting me in the chest.
Yes, sir.
And the distance between that barrel and my chest is. No, that's
Is that close?
It's 29, 30 inches. 30 inches. 30 inches. That's what this says to me. 30 inches.
Yeah, with this shotgun.
Okay, right. And so I would get, just a minute ago, we said at 36 inches, or you said maybe it was closer. I mean, is this consistent with Stifling?
Yes, sir, within 5 foot, yes, sir.
Okay. And when we had it before and you were shooting up at me, it was about the same distance, maybe six more inches between the barrel and me, right?
Mhm.
And there's no Stifling.
Okay.
Okay, you're the expert. What does that mean?
Well, he also has, I don't know if I can answer that.
Could it be? Well, I mean, on that first shot, we know, you say that he was, whatever you call it, same jet, what's it called?
The ejection port.
There you go. The ejection port had to be inside the room.
Yes, sir. Well, the second shot, now all it had to be is pointed toward the room.
Why?
Because it's going to eject to the right. So if this is the door frame and I've got the ejection port pointed toward the room, it's going to eject into the room. The first shot, because it was straight on, had to be at least past the door frame.
Right. But the second shot, if the ejection port was
Pointed toward the room.
pointed towards the
I could
room.
be this far away from the door, the second shot, and the ejection port would still throw it that direction.
So doesn't that change the calculation here on how far away that gun was? Because the ejection port on this, is that a thing? Where is it? There it is right there. The ejection port is, who you disagree with me, about 28 inches from the barrel.
On that shotgun, yes, sir.
Let's assume this was impossible. Although it doesn't match up with the ejected mark on the shell sound in there's some theory that this would be about the same shot. So you would agree with me that the shooter would have been, how about showing you again how low they would have holding this?
Other side, but here.
Down.
Well, I mean, I don't know how long the arms are. There's a lot of variables there, but it could have been here. It could have been here. I mean, I can't tell you the mechanics of it. All I can look at is the angle.
And that angle, you would agree with me, is an unusual angle. Typically, people shoot a shotgun from their shoulder.
Typically, unless you and I are both occupying nearly the same space,
Wouldn't there be stippling or powder burns or something?
I can't explain that. But
Well, okay, so you can explain it. I'll take that.
Yes, sir.
But it would be inconsistent for them to be that close, wouldn't it?
Well, you figure if Paul made it to the door, whoever fired the first shot could have retreated or could have backed up, better word for it, could have backed up or even was taking cover to see what was going to happen. And then I believe the angle would fit or could fit that two persons could be that close to that door frame.
Hand me the weapon again, please. Might not shut that way. I'll be blocking the door.
Oh.
That's better. So we both agree that the first shot is square into his chest.
Well, I can't say square, but it's directly on. Yes, sir.
Okay, which is at shoulder height. Boom.
Well, it could have been shoulder height. It could have been like I was holding it just now. No. Before. I mean,
I'm sorry.
it could have
I
been.
my own.
It could have been here. It could have been here. I mean, I can't tell you the
But he's holding,
mechanics.
whoever's shooting him in the chest is holding it.
Parallel to the ground or
Parallel to the
near
ground.
parallel to the ground. Yes, sir.
You know it went down here.
I don't believe so. No, sir. Not the path of the bullets going out to that one.
Okay.
The pellets. Not
So either at shoulder or just under shoulder. Now, shotgun has pretty good kick to it, doesn't it? Buckshot?
yes, sir. Pretty decent.
So I guess what I don't understand, and you have no explanation for it, is why the second shot would be like this. I mean, we agree the normal height person would have to crouch to make that shot, correct?
I don't know where they want to get into that barrel place, Mr. Harpoon. I can't tell you that part with my science. I can't. All I can look at is the angle,
Which is about like this,
well, it's here, but in reverse.
which is about like this, correct? The barrel would have to be, okay, like that. But you would agree with me, I'm bent over to do that.
You are, yes, sir.
So the shooter was a very short person?
But here, I'm not bent over that far, and I'm almost 6 foot. I mean,
So what, I don't understand. You go ahead, Steve. I don't understand what circumstance would cause a person to, to do this or this, and then immediately do this or do this to put that second shot in.
Objection, asked and answered.
You said what you don't understand. The question is,
The question is that your position is that the first shot was like this. The second shot would have been like, if I'm standing up straight like this, not a very good aim, or crouched down. If it's a normal sized person, right?
the first angle was almost parallel with the ground.
Right.
The second angle was somewhere between 100, somewhere around 135 degrees from the door frame. I can't tell you the psychology of any more or any less.
Okay, so what height was the entrance wound on that chest?
On the chest?
Yeah.
Approximately 4'3" or 4'4", I believe, according to the,
4'3".
yeah, 4'3", 4'4".
Because it's under, that would have been below the shoulder wound, right?
Yes, sir.
So it'd be, let me see how that works. Maybe this one will just. 2, 3, 4, 4 foot. You think 4'3"?
I'm fairly certain, yes, sir.
You trust me, that's 4'3"?
I believe that.
Okay, and I'm about 5'10". On a good day. So that would be about right for me, wouldn't it?
Yes, sir.
Okay, so that first shot, if it's on that person's shoulder, if they put it on their shoulder, they would have been approximately, was there any way to figure out?
I don't know a scientific way, Mr. Harpoon, unless you had a tripod that you could hold the gun and shoot it many times, the actual gun, and measure it. I don't know the scientific. If it is one, it's way out of my purview. I look at the angles and I look at the damage and I develop my angles. That's what I do.
Okay. Okay, I think I'm done with the gun. You can have a seat.
Can I take the gloves off? We can do this again.
Objection, asked and answered.
I think we're done with the gun, but I got to tell you. So, I don't think I need this anymore, Mr. Barber. I'm sorry. Were you able to find what I wanted? What is it? Okay, so let me go a couple other places with you. You were hired on December 22nd?
I think it was in November when I first got to review the evidence, and I think I was hired in October. I can't tell you the actual date on my retainer, but it was several weeks after that before I ever got access to evidence.
Okay, so you read a crime scene reconstruction done by a guy named Bevel from Oklahoma, did you not?
I did read that, yes, sir, but I did not depend on that to make my determinations.
No, I'm just saying,
Okay, yes, sir.
for purposes
I did
of-
review that, yes, sir.
Okay, and do you remember when he generated his report?
I don't, Mr. Harpoon.
Would it surprise you if he generated it in 2022, early? Several months before you even asked, right?
Yes, sir.
Okay. And you were their second choice?
I don't know if I was their second choice. I was a choice.
Okay. Let me make sure I understand the date of Mr. Bevel's report. So he issued a report in March of 2022, and you were not asked to get involved until October of 2022.
I had a phone call early, shortly after. I don't even remember who I talked with, but someone called me shortly after the homicides and asked me if I would mind taking a look at stuff. And I said, I'm always available to help if I can.
Okay. Now, the other things that you looked at, let me just make sure we understand what you looked at. You had a David Green recording of June 7th, 2021. Remember looking at that?
Body camera. Yes, sir.
Right. And in that body camera interview, when they talked to Mr. Murdaugh, he indicates the phone had fallen out of Paul's pocket when he tried to check his pulse, and he put it on. It didn't explode out of anywhere. He put it on that picture that you introduced just a moment ago. He put it on his rear end. Correct?
It may have said that in the body
Okay.
camera.
So there was no exploding out of any pocket, right?
I don't believe it did. And that's what I said. Someone other than Paul put it there.
Okay. Now you had a SLED crime scene investigator summary. Was that by Agent Worley?
I read several SLED reports, but Agent Worley's report was one of them. Yes, sir.
Okay, and you digested everything in that report that was relevant to your inquiry?
I read those reports just so I have the knowledge of it, but what I can work out on my own, even if it contradicts their results, I like to make my own.
For instance,
conclusion.
she had very distinct measurements on shell casing location, right?
Yes, sir, I believe that.
And you relied on that, certainly, in looking at shell casing placement.
When you say shell casing, are you
I'm
talking
about where the Blackout 300 shell casings were?
I looked at the path. I did not look at the measurement per se, because like I said, the shooter moving, the victim moving, not having the rifle and be able to say exactly where it throws that shell casing, I don't get too involved with that. I'll look at the general path where they're at. But as far as so many feet, so many inches, I don't pay a lot of attention to that.
And I'm not asking that, but it would show you the path of the shooter, would it not?
Well, like I said earlier in my testimony, it could or it may not. You can't look and say a shooter started here and ended here, because he might have went from here to here and back to here. So
Well, let me rephrase that. Not necessarily the path, but at least you would know generally where the shooter was during, if you look at the coagulation of all those shots. For instance, what we see, if you remember correctly, is a number of these shell casings. There's one sort of back on the gravel road, and then all of the rest of them are located in a fairly small area on the grass. And then there's one under her, right?
yes, sir.
Okay. And that would show you, at least generally, I mean, the one under her had to have been a shot that was fired while she was upright and fell on it, correct?
I would agree with that
Okay.
assessment.
But give you some general idea where the shooter was. General idea. Not
General
exact-
idea, somewhere within 5 foot or 5 or 6 foot, knowing what I know about those rifles, it's not going to throw it 20 foot or 30 foot. It's going to be confined to that area. And all I can do is probably put a general perimeter within, a couple yards at the most from Miss Maggie Murdaugh.
Did you look at the autopsy report?
I did, yes, sir.
And the autopsy report, Dr. Reamer indicated the angle of the shot we talked through that was 135 degrees.
I really wasn't aware of that, but I look at the photos more than the report part.
Okay, hold on 1 second here. Let me see if I have it. Let me ask them to find something. Let me ask you what else you looked at. And you list a bunch of things here. You looked at lab photos of victims' clothing, trace reports, DNA, CS. What's CS photos? Evidence processing. What's CS mean? Crime scene.
Yes.
Okay. So you looked at the crime scene photos. There are 449 of those, or at least the ones that were relevant to what you were looking at, right?
Yes, sir.
And a number of interviews with people, right?
I had access to it. I may have looked at some of them. Yes, sir.
Okay. Now, let me ask you this. Does the wound on Paul's shoulder indicate to you how far the shooter was? I mean, what was the spread at that point?
Your typical full choke on a shotgun, and it depends, once again, it depends on the choke.
Right.
At 3 foot, it's going to spread 1 inch.
Okay. Well,
With an improved choke, at 3 foot, it's going to spread 1.75 inches. So I don't know
you looked at the autopsy photos.
I
Right?
did. Yes, sir.
Was the wound on his shoulder bigger than 1 or 1.75?
It's a massive wound. I mean, it's massive, but a lot of that can be taken into the angle too, Mr. Harpootlian.
Did you look at the x-rays?
I did. Yes, sir.
And there's a whole bunch of pellets in his shoulder.
Along the path, yes,
Along
sir.
the path. But wouldn't it indicate that the spread of those pellets is significantly more than 1 inch or 2 inches? Like, I think we determined it was about a 6-inch spread.
Well, I don't think with the angle, it would be possible for someone to be 12 yards away and shooting up that direction. So obviously that's got something to do with the close proximity and the way those number twos work.
So, do you have an explanation for why the spread would have been that big based on what we just did? I don't want to pull the shotgun out.
I'm not a firearms examiner, Mr. Harpootlian. I'm just familiar with how they work.
And so your position is that spread is not inconsistent with what you've
I
testified?
do not believe so. I have had people shoot themselves in front of me, and I have worked a number of crime scenes where I've seen the same damage.
Okay. So, okay, here we go. I knew I'd seen it somewhere. This is your report.
Thank you.
Okay. So let me ask you, did you say Paul's height 5'8" and a sharp angle upwards, approximately 135 degrees, support that Paul's left side was dipping slightly, head slightly forward as he was standing or exiting the feed room at the time of the second shot?
I think that's what I testified to. Yes, sir. And that's still my findings.
Okay, I just want to make sure this 135-degree thing I didn't imagine. That's what you said, right?
Well, that's what I was saying. I was hoping you didn't say I copied someone else, but yes, sir. That's my measurement.
Okay, so you also said the length of the shotgun would be needed to a reasonable degree of certainty, but it's unlikely the shooter was standing with a shouldered weapon at the time of the second discharge. We've already established that, correct?
Yes, sir.
They would have been crouched or holding it down in some awkward position.
Yes, sir.
Rather than having it up to their shoulder. Also, let me see if I can finish this. You don't have, you do, in your opinion, IQ 7, it's my opinion that the exact position of the shooter cannot be determined in relation to Margaret, correct?
Yes, sir.
Do you have the most accurate information available to narrow down the position of the shooter's position is the physical location, position of the deceased, bullet path of known wounds, stippling, or active physical damage caused by those wounds. So you came across no data that would allow you to determine trajectory with any degree of certainty as to Maggie.
No, because the victim and the shooter could possibly have been moving. So it's no way, to my knowledge, scientifically, to prove either one.
Okay, and I guess that wasn't my question. My question was, you saw no data in the material you looked at that would allow you to do that.
Other than the pathologist measuring the angle of her stomach wound and her thigh wound, and they were very similar angle, that's about all I can tell you, Mr. Harpootlian.
Okay. And let me deal with a couple of issues. Let's go to the what you testified to about the impression on her leg, right?
Yes, sir.
Now, this again, was there a photo taken of either her leg or the tire that you're talking about that would have been what you would expect if you're trying to make a comparison? That is a 90-degree shot of either one.
And no, sir. And that's why I explained that I can't call this to the exclusion of all others. If I was going to make an absolute identification, I would require a scale photograph.
Right. And there's no scale in either one of those.
No, sir. But I got it close, but still not close enough for me to call. I used the scale at autopsy that the pathologist used on the back of Miss Margaret Murdaugh's leg. And I went and did research on the tire, and I actually know the type of tire. And the only problem is it comes in a 9, a 10, and an 11-inch front tire. So I have no way to scale that without the actual tire.
So you're not telling this jury that it's your opinion that tire caused that impression on the back of her leg?
What I'm telling the jury is that is a class. They share the same class. It's called an association. And in my opinion, either that tire or a tire just like it caused that impression.
Well, let me ask you this. By the time it got to the autopsy for her leg, whatever mud was on there was washed off, right? There was no, in those autopsy photos, all you see is a bruise, correct?
That is correct.
Okay. And so the only evidence you have is that there was some mud stuck on the back of her leg with those specific details, right?
It's an impression in mud. Yes, sir.
Okay. When you looked at the tire pictures, was there any mud on them?
There are, specifically those treads. And like I pointed out earlier, you can actually see unique random characteristics. In a perfect world, if I would have had a scale myself, I would have called that all day, and my technically reviewer would have called it all day also, but I'm not allowed to do that.
You're not allowed to do that because you may be close, but you can't say with affinity that tread caused that defect.
What I can say is that, in my opinion, that impression was created by that tire or a tire with similar characteristics.
Did you look at any black and white images of that what you call a tire impression or the mark on the back of her leg?
I did. I made it black and white. Yes, sir.
Okay. So, okay. You can go round and round about how sure you are, but I'm not going to do that. Let me ask you sort of in not closing. I have a couple more shots, but a couple more questions. Strike that. Let me check one thing with my folks over here, and I'm probably done.
Can I stand for a moment, please? Your Honor, thank you.
Everybody stand up. Okay. Andrew, you ever-
Yes, sir. Just real quick. Couple things real quick. You were contacted by SLED to review this case, is that correct?
Yes, sir. It was.
And were you told any particular conclusions to come to, or did you do a fresh review and arrive at your own conclusions of your own independent judgment?
Every conclusion I came to was in spite of any pre-existing conclusions. I made my own conclusions.
You're asked a little bit about the tire mark impression, and were you relying on the crime scene photographs of Maggie Murdaugh at the scene?
Yes, sir.
And did you see mud, which is the impression that you examined?
It is. Yes, sir.
And from your review of the crime scene, was there any other ATV in the vicinity of where Maggie Murdaugh was found, except that tire you looked at, the picture of it?
That's the only one I observed.
And you said it either had to be that tire or a tire with similar characteristics
Yes, sir. That's my opinion.
on the ATV that was at the scene.
Yes, sir.
You were asked a lot about shell casings, and you pointed out that they can be thrown different feet and can move around, and shooters can move as well. Is that correct?
That is correct.
The shell casings, though, that were located, were they located in this area around the feed room as to where Maggie Murdaugh was found?
They were.
And you said them shell casings ain't gonna get thrown 30 feet, right?
No, sir, not in my experience.
In your experience, having done 850 homicide scenes, can shooting events be fluid situations?
That's death scenes, but the answer is yes, sir.
The victims can move,
Yes, sir.
the shooter can move,
Absolutely.
people can change their aspect of how they're positioned at any given time.
Because of the moment.
If I get to it on that easel, y'all went through the whole thing, drawing and all the rest of it. But what y'all were drawing, that was actually reversed from how everything happened. Is that correct?
It was.
And if this were the door to the feed room going out to the outside and I was standing in it, which direction was the trajectory of the shot to Paul's head?
Where I'm at, up at a 135-degree angle.
And what did you observe up here?
I observed body fluid, a concentration of body fluid as a result of a gunshot wound.
Defects in the door as well?
Absolutely.
And what's a defect? What is that?
A defect is damage caused by a projectile, whether it be a pellet or a bullet.
That easel drawing y'all did, that was reversed from the reality of the situation, correct?
Yes, sir.
All right. And that easel also was slanted as well, was it not?
It was.
And if it were actually standing straight up, that dot y'all were marking would actually be higher than it was when it was demonstrated to the jury. Is that correct?
Yes, sir. And that's why you use approximate, because I can't tell you how Paul was positioned. I can only go by the angle.
All that stuff that you and Mr. Harpootlian did with the easel and the shotgun and all the rest of that, does any of that change your opinion about what happened to Paul on the night of June 7th, 2021, when he was fatally shot in the head?
It does not.
Thank you, Your Honor. Nothing further.
Just one additional question.
Yes, Barbara, please.
We agreed that what I did there a moment ago with the easel was a mirror image or a negative of what actually occurred, right?
It was the opposite side of the door. Yes, sir.
Go get the door, please. Mr. Barber, in the interest of justice, has allowed me to point the shotgun at him, Your Honor. It is. So we agreed that if he's standing in the doorway, the shooter would have had the shotgun. And how about turn a little bit to your turn that way? A little bit more?
Yes, sir.
Okay, the shotgun would have been about like this. About like this.
Yes, sir.
Okay. Okay. So that's the trajectory. That's where the barrel of the shotgun would have had to been.
In my opinion, yes, sir.
Okay, thank you. No further questions.
You may step down. Yes, sir. Ladies and gentlemen, we're going to break for lunch at this time. Members of the jury, I'm appointing juror number 826 to be the foreperson of the jury. The foreperson has the responsibility of serving as the spokesperson for the jury from this point forward. Will have the responsibility of presiding over the jury deliberations, and will have the responsibility of completing the verdict form representing the unanimous verdict of the jury when we reach that point, and also sit in the first seat, which is the seat designated for the foreperson. Understand? All right. Very good. We'll see you all at 2:15.
Remain in order. Order.
We'll be in recess till 2:15.
All right.
Special Agent Kelly, how you doing today?
I'm doing well, sir. How are you?
Doing well. If you would just quickly introduce yourself to the jury and just give them a short synopsis of your career in law enforcement leading to where you are today.
My name is Ryan Kelly. I'm a senior special agent with the State Law Enforcement Division. I'm from Berkeley County. I went to college at the Citadel where I studied biology. I attended the South Carolina Criminal Justice Academy. I've got approximately 22 years of law enforcement experience, the last 10 of which have been at SLED Investigative Services Low Country Region, where our caseload includes violent crime, public corruption, officer-involved critical incidents, and financial crimes. I'm currently there as a senior special agent.
All right, and if we get that mic just a little bit closer to to yourself.
Is that better?
Yep, that's much better. Have you, as far as the murders at Moselle, you had a very tangential role in that particular case, is that correct?
That's correct.
Moving forward, did you become the lead case agent on a different matter that started on about September 4th, 2021?
Yes, on September 4th, 2021, there was an incident involving Alec Murdaugh where he was shot along Old Salcahatchee Road in Hampton County.
All right, and did you respond to that particular scene?
I did.
Okay, and about what time did that occur?
The shooting occurred at approximately 1:36 p.m.
All right, and that's September 4th?
September 4th, yes.
As you arrived at the scene, what, if anything, did you notice about what vehicle was there?
Well, prior to arriving at the scene, while en route, Mr. Murdaugh was being treated at a hospital in Savannah. So I responded to Savannah first. After meeting with Mr. Murdaugh, I then responded back to the Salcahatchee Road.
Okay, and we'll talk about that in a bit. But let me ask you about the scene a little bit. What vehicle was at the scene?
There's a black Mercedes SUV.
Right. And do you know who that Mercedes belonged to?
Yes.
And who did it belong to?
Maggie Murdaugh.
All right, and what information had been, you said you responded to Savannah Hospital, is that correct?
That's correct.
All right, and you had a chance to talk with the defendant, Alec Murdaugh?
I did.
And do you see him here in the courtroom today?
Yes, he's there in the brown blazer in between Mr. Harpootlian and
let me ask just a little bit about the scene before we get into that. What, if anything, did you notice about the condition of the vehicle?
the vehicle had a driver's side rear flat tire.
Okay. And did you notice anything about that particular tire? The class of tire was, or what kind of tire?
That particular tire is a run flat.
All right.
So the tire was flat, and when we got there, we expected to see some type of damage to the tire, to the inner wall or whatnot, and that just wasn't present. After reviewing the tire and looking at it up close, we saw what we thought appeared to be a small puncture wound or a puncture mark on the sidewall.
All right. And what did that appear to have caused that as you looked at it?
It looked like a small blade, like a pocket knife that most police officers would carry in their pocket. It appeared to be something similar to that.
Tell the jury a little bit about a run flat tire. What does that mean if the tire goes, quote, flat?
Well, I don't work for Mercedes and I'm not a tire expert, but it is it's a feature on certain brands of tire that once there is some type of puncture, that the tire remains operable. So if you're driving on a road and you suffer a blowout, it allows you to drive to a safe space, where you can pull off and seek assistance there. But they typically don't go flat immediately after being punctured, unless there's some catastrophic damage to the tire. And in this case, there was not. That catastrophic damage was not there.
All right. In the stand by for me just real quick. All right. In the course of your investigation, as you started looking into this, did you obtain copy or review the 911 call from this particular incident?
Yes, I did.
All right. And who made that particular 911 call?
Alec Murdaugh.
All right, and I'm going to show you what's been marked as States 543. And does that just contain that particular 911 call?
Yes.
All right, Your Honor, at this point, I would move in States 543, I believe without additional objection.
Without additional objection, Your Honor.
It's admitted.
All right, thank you. I'm going to go ahead and play that. Here. Let me ask you this. While we're getting that 911 call up, can you generally describe what was reported by the defendant on 911?
Yes. Mr. Murdaugh called 911. The Hampton County 911 operator answered the phone, obviously asked, what's your emergency? Mr. Murdaugh said that he was on Salcahatchee Road by a church with a red roof. When she asked what had happened, he said that he had been driving on Old Salcahatchee Road, suffered a flat, and when he pulled over, another motorist arrived on scene to render assistance, and he said that when he turned around, the motorist shot him. So at that point, the dispatcher asked, have you been shot? And then that's at that point where Mr. Murdaugh said, yes, he'd been shot. But then he said he was okay.
All right. And did he say that he got a flat tire, he stopped, and then someone stopped to help and then shot him?
Yes.
All right.
For a lady and members of the jury, we have to go to the jury room for a few minutes. Please do not discuss the case.
What church? What church are you talking about? I don't know the name of it with the red roof. Okay, what end of South Hampton Road? Because I don't know what you're talking about. At the Hampton County side. Okay, what's going on? I got a flat tire, and I stopped, and somebody stopped to help me, and when I turned my back, they tried to shoot me. Oh, okay, were you shot? Yeah, but I'm okay. You shot where? Where were you shot at? Huh? Did they actually shoot you or they tried to shoot you? They shot me. But, okay, wait, you need EMS? Well, I mean, yeah, I can't drive. Okay, and I'm bleeding a lot. What's all your body? I'm not sure, somewhere on my head. Your head? Somebody just talking to me there. For 911. Okay, still? Hey. Okay, let me speak to him, see if he can tell me exactly where you are.
For the record, I'm stopped at 141. Was that the defendant on the 911 call?
Yes.
At that point in time, he said someone shot me?
Yes.
Did he identify who that was?
No, he did not.
I'm going to show you what's been marked as Stakes 545. And is this a copy of a body-worn camera video you received from the defendant in the ambulance at the scene?
Yes.
And by the scene, we mean the side of the road on September 4th.
Absolutely. South Hatchie Road, September 4th, 2021.
Your Honor, at this point, I'd offer Stakes 545 and evidence, I believe, without additional objection.
No additional objection, Your Honor.
It's submitted.
All right, for the record, I'm going to publish a portion of that video.
Tell me what else. I'm going down the road. I had a tire go flat. I pulled over, and this car went by me. And I didn't pay a lot of attention to it, but then it turned around, came back. A real nice guy, acted like, and I turned my head, and I mean, boom.
Okay, you know what kind of gun it was?
I don't know what kind of gun it was, but it sounded like a shotgun, even though it was so loud. It didn't sound like a 22. I know that's what they think it is, but it didn't sound like a 22.
It looks like a small caliber hole. Yeah, small caliber. Yeah, small caliber.
But it was extremely loud. Like
What's your name?
Alex Murdaugh.
What's your name?
527-68.
You're good. What's a good telephone number, Murdaugh?
942-1227.
What's your address?
PO Box 457.
457 Hampton. So you said the blue for the pickup, is it a Ford, a GMC, or what?
It wasn't a Ford, I know that.
It wasn't a Ford. Like a Ram type or?
You know, I think it was a GMC or a Chevrolet, but
GMC?
I'm not totally positive.
I got one on my car. So you try to find time, make sure you're doing one side of the road, try to change the tire. One side of the pickup, came inside, you, everything's okay, and it's you take the shop in the shop. How many times the fire?
I think just one time.
What time?
I lost my position right when it first happened. And I think I put
All right, for the record, I played that clip from about 14:07, 14:10 by the timestamp. Was that the defendant in the ambulance at the scene on Salkatchee Road?
Yes, it was.
And did he again tell the story that he had been shot by an unknown assailant?
Yes, the story was consistent.
All right. And did he say at any time during that anyone shot him?
No.
And what did he say the weapon sounded like that shot him?
He said it sounded like a shotgun.
On September 4th, you said you responded to a hospital?
Yes, in Savannah, Georgia.
All right. And who did you see when you were there?
I met with Alex Murdaugh and I met with Randy Murdaugh.
All right. And did you have a conversation with the defendant?
Yes, I did.
All right. And can you just very generally relate what the defendant said? Did he tell you a very similar story that we've heard from the 911 call in the ambulance video?
Yes, when we arrived in the hospital, Mr. Murdaugh was receiving treatment. He was awake and willing to talk to us. At that point, he was the only witness to this incident. We asked him what happened, and he told us a story that was consistent with the 911 call and with what was told to the deputy.
All right. And did he state that that a driver had stopped, passed by, turned around, and came back to a location?
Yes, he said the similar story that he was driving along Old Salkatchee, that he hit something significant with his tire, causing it to go flat. So when he pulled over to the side of the road to inspect the tire, it was flat. As he was doing that, he said a dark and colored Chevy pickup truck drove by, passed him, turned around, and came back to his location. He said he made contact with the driver, and as Mr. Murdaugh turned around to walk back to his vehicle, he said the driver then shot him.
Did he say that the driver of the truck seemed very nice?
He described the driver as a very nice-looking male between 30 and 45 years of age.
Did he tell you what he thought the weapon was that shot him with?
Yes. While he initially said it was a shotgun in the ambulance, when we met with him at the hospital, he identified the weapon as possibly a .22 caliber.
Did he say whether or not he ever lost consciousness?
He said that he lost his vision, dropped down to his knees. He did not believe he lost consciousness.
Did he describe the vehicle of the person that supposedly did this?
Yes. He again described a newer model, dark and colored blue Chevy pickup with, I believe, some type of sport tires.
And did he describe the driver at all of this, that supposedly was the person who shot him?
Yes, his description of the driver was consistent, a white male between 30 and 40 years of age. He described him as nice looking, a nice person. He described him as having close cropped hair with a close cropped facial hair.
And did he state whether or not he would recognize this unknown person if he saw him again?
Yes, Mr. Murdaugh told us that if he were to see the person again, he would be able to identify him.
At any point, did he identify specifically any individual, or did he claim that this was an unknown person?
He never gave a specific individual's name. He just said it was someone he did not know.
We'll return back to the scene. I'm going to show you what's been marked as states 544. All right, I'm going to show you what's. Thank you. I'm going to show you what's been marked as states 544, and see if you recognize this particular image.
I do. This was recovered from inside the black Mercedes SUV driven by Mr. Murdaugh. It is his assistant solicitor's badge.
Can I have the helmet real quick, please? All right, is that what's on the screen right now for the jury to see?
Yes, it is.
All right, turning back to now, let's move into September 5th. Did agents with law enforcement continue to sort of search that scene where the Mercedes had been located?
Yes. So on September 5th, agents returned to the scene. We were looking for any evidence of involved in the accident. We were looking for the significant piece of debris. And as we were searching the roadway around where the Mercedes had pulled off, we searched across the street in the grass area, and we recovered a gray in color utility knife.
Did law enforcement, did you notice any sort of debris or anything like had been described by the defendant as supposedly causing the damage to the tire?
No, we searched the area extensively, and we never were able to locate the significant piece of debris that Mr. Murdaugh described as causing his tire to go flat.
I'll show you what's been marked as states 546, and do you recognize that image?
Yes, I do.
And tell the jury what that is, please.
That is the folding knife that was recovered across the road from where Mr. Murdaugh's vehicle was parked.
All right, this time, I believe without additional objection, the state movement states 546.
No additional objections, Your Honor.
It's admitted.
All right, and is that the knife as it was found laying in the grass?
Yes.
And again, where was that location in relationship to where the Mercedes was?
The Mercedes was pulled off to the side of the road. This was directly across the road in the grass on the other side.
Was DNA testing ultimately conducted on this particular knife?
Yes.
And were two individuals in that DNA testing that came back in the propositions as a result?
Yes, DNA profiles of both Alec Murdaugh and Eddie Smith were identified on the knife.
In the course of the investigation, did you uncover any evidence that not long before this event occurred at 1:34 or so on September 4th, that the defendant had had a confrontation with an individual?
Yes.
And who was that? Remind the jury of that, please.
Prior to going to Salcahatchee Road, Mr. Murdaugh met with Chris Wilson.
And can you remind the jury what generally that discussion was about?
Mr. Wilson and Mr. Murdaugh met. Mr. Wilson, at that point, Alec Murdaugh had been terminated from his law firm, and Mr. Wilson became aware of that, so he wanted to meet with him to discuss what was going on, because obviously Mr. Wilson and Mr. Murdaugh had the missing $192,000 from the previous months that was still ongoing.
On September 6th, did you return back to the Savannah Hospital?
Yes, I did.
All right. And did you have another conversation with the defendant?
Yes. When Mr. Murdaugh advised us that he would be able to, would recognize the individual if you should see them again, SLID has at its resources a composite sketch artist. So we brought her down, and her and I went to Savannah back to the hospital to re-interview Mr. Murdaugh in an attempt to create a composite sketch of the unknown suspect.
All right. And just very quickly, what is a composite sketch?
Again, I'm not a composite sketch artist, so I'm a layperson as I describe this. It is where an artist uses a digital software in concert with resources of magazines of certain body types and skin tones and whatnot, and allows the victim to like a catalog to go through and find the identifying features closest that fit the unknown person, and those various parts are then drawn together to create a composite sketch.
All right. And during that particular interaction, was the defendant able to answer your questions?
He was.
Did he respond appropriately to subject matter?
He responded appropriately. He was able to answer the questions asked of him. And again, we started from the beginning, and he again went over the entire scenario of what happened on the 4th, and it was consistent with the versions he had given us previously.
Did he agree to have this discussion with you?
He did agree.
And did you go into some discussion again with what happened on the side of the road, at least according to him at this point in time?
Yes.
And was it consistent with what he related before?
It was consistent.
Did he describe this unknown individual?
Again, he described him in a similar fashion: white male between 30 and 40 years of age, was nice looking, close cropped hair, manicured, close facial hair. I believe he described him as wearing some type of outdoors type shirt. The description was consistent with what he had previously told us.
Right. And did he also provide a similar description of the vehicle that this individual was driving?
Yes, again, a dark and colored Chevy pickup truck.
And yet again, at any point during this period of time, did he identify who this person was, or did he say it was an unknown assailant?
Never identified who it was, and continued to tell us it was an unknown person.
Did he work with the sketch artist and looking through books and working to make a sketch of this supposed unknown assailant?
Yes, the sketch was completed.
And did that take a relatively extensive period of time?
Looking back, I don't know the exact approximate, but it probably took a couple hours for the interview and the sketch to be completed.
All right, I'm going to show you what's been marked as States 547 to your testimony and see if you recognize that image.
I do. This is the composite sketch.
All right, Your Honor, at this time I would offer States 547, I believe, without additional objection.
Another additional objection, Your Honor.
It's admitted.
What is this image on the screen?
That is the composite sketch created with the assistance of Mr. Murdaugh.
Based on his descriptions to the sketch artist?
Based on his descriptions.
This is on September 6, 2021?
September 6, 2021.
That evening, did law enforcement receive any communication from the defendant's family?
Yes, on the evening of September 6th, Special Agent Owen received a call from Mr. Murdaugh's brother, Randy.
All right, can you relate what the investigation learned from that particular conversation?
Alec Murdaugh was still in the hospital in Savannah. Randy and the family had been down there with him. Randy called Special Agent Owen to let him know that Alec had been making calls from the hospital to some unknown numbers. So Randy provided those numbers to us.
And was information related that he had contact with hospital staff?
Yes, Randy told us that Alec was trying to convince the nursing, the medical staff members to allow him to use the phone so he could make phone calls.
And was information related that he was actually offering the staff money to try to use their phone?
Yes, one of the nurses in their notes made note of Mr. Murdaugh trying to offer money to use their phone.
Did the family of Mr. Murdaugh relate a specific name and a number to law enforcement as they discovered that Alec was attempting to contact this person?
A specific name and number were provided to us. Curtis Edward Smith. We were able to take the telephone number and trace that back to Mr. Smith.
During the course of this particular investigation, did law enforcement obtain any surveillance footage from any nearby establishments?
Yes, we did.
And can you describe that to the jury, please?
After the shooting, the agents who are present on the crime scene, obviously part of our investigation is to canvass the area. There was St. John's Baptist Church was nearby. Agents made contact with staff there. They in fact did have surveillance video that captured the roadway of Salcahatchee Road. Reviewing the footage, we first looked to isolate Mr. Murdaugh's black and color Mercedes. That was something that was unknown to us. That he went that way, it would have been seen. And as we continued to review the footage, we started looking for a blue and color Chevy pickup truck. At 1:25 p.m. approximately, we observed a blue in color Chevy pickup truck with a gold or yellow in color passenger front quarter panel. Passed by at 1:25, approximately 20 seconds later, Mr. Murdaugh's black in color SUV passed by. At 1:30 p.m., the blue in color pickup truck was seen driving back the opposite direction away from where Mr. Murdaugh would have been.
All right, I'm going to show you 3 images that have been marked states 548, 549, and 550, and see if you recognize these images.
Yes, this is the 1:25 p.m. image. The first image is the pickup truck with the gold front quarter panel. The second image is 20 seconds later, approximately, with the black and color SUV. And the third image is at 1:30, 5 minutes later, with what appears to be the blue and color pickup truck driving back the other way.
Your Honor, this time the state would offer states 548, 549, and 550, I believe, without additional objection.
No additional objection.
They are admitted.
All right. Putting this up on the screen, we have the timestamp up here. Is that correct?
Yes.
And what is that right there?
That is it is a dark blue and colored Chevy pickup truck with a gold front quarter panel.
All right. 549. What does that image reflect?
It is the Mercedes SUV.
Going in the same direction?
Going in the same direction, approximately 20 seconds after.
And then 550, what does that reflect?
That is at 1:30 p.m., approximately 5 minutes after the initial vehicles were seen. The blue Chevy truck appears to be driving in the opposite direction.
Did law enforcement travel to any particular residence in light of the information that had been provided by the defendant's family about the calls that the defendant was making?
Yes, once we were able to identify Curtis Edward Smith, we quickly learned that he was a resident of Walterboro, South Carolina. So we were able to go to his residence the morning of September 7th, and we were able, he lives at 1075 Burlington Road in Walterboro. Agent Owen went by and was able to locate or observe the blue in color Chevy pickup truck with the right front gold quarter panel.
Was a search warrant conducted of that residence?
Yeah, a search warrant was obtained and executed on the residence.
What date was that?
September 7th, 2021.
All right. And during the course of that search warrant, was there some narcotics found?
Yes.
Was there a ledger found?
Yes. So a small amount of narcotics. Mr. Smith lives in his garage, a modest home. Over the course of the execution of the search warrant, narcotics were located inside the garage. But the search of the residence, we found the best way I could describe it would be a physician's desk reference of multiple narcotic pills, like a drug reference guide that he had made personal notes in.
And was there any sort of notebook with a ledger in it or anything like that?
Yes, there was also a small spiral notebook, a 3.5-inch spiral notebook that had various, it looked like, obviously it wasn't completed by an accountant, but there was numbers and there was pills and descriptions of it looks like some type of sales ledger.
All right, I'm going to show you what's been marked as states 551 and see if you recognize this image.
Yes, I do. These are transaction receipts and deposit and withdrawal receipts for Curtis Edward Smith's Enterprise Bank account.
And ultimately, did the law enforcement look at some of this financial information and trace that back to the defendant? This was recovered in Eddie Smith's house, correct?
Yes, those documents were recovered in Mr. Smith's house. At this point, Alex Murdaugh had been fired from his law firm for stealing from clients and from the firm. We were aware of that information. It was told to us that Mr. Murdaugh had a prescription drug addiction that we were aware of. At this point, we were aware of that Mr. Murdaugh had reached out to Mr. Smith from the hospital. So when we found, like I said, Mr. Smith lives in a modest house, has a modest vehicle. When we're seeing several $100,000 of deposits and financial records for Mr. Smith's Enterprise Bank, we obtained a search warrant. Through the execution of that search warrant, the funds were tied back to checks written by Mr. Murdaugh.
And did those funds continue up until the time of the murders at Murdaugh?
Yes, they did.
Did they continue afterwards?
They did.
Your Honor, this time I would offer states 551 in evidence, I believe, without additional objection.
Without additional objection, Your Honor.
It's admitted.
Did the investigation obtain any information from Blanca Simpson about any communication she had with the defendant that day, September 4th, 2021?
Yes, Ms. Simpson made contact with Mr. Murdaugh, where Mr. Murdaugh had requested her send him copies of their insurance cards.
Was that prior to the incident occurring on the side of the road?
Yes, prior to the incident, Mr. Murdaugh attempted to meet with a few individuals, Mr. Wilson being one of them, and he made contact with Ms. Simpson via telephone.
In light of the information that had been uncovered about Eddie Smith and the financial connection between Eddie Smith and Alec Murdaugh, did the investigation seek to re-interview Alec Murdaugh?
We did. I reached out to Mr. Arbulian on the day of September 7th, 2021.
All right. And over the course of the next few days, Was the defendant going to rehab?
Yes, we communicated regularly with Mr. Apuli and Mr. Griffith. They made it known to us that Mr. Murdaugh had entered into a rehab facility that was out of state. So at that point, we were making an attempt to interview him. We made plans to travel to Atlanta, where we believe Mr. Murdaugh was, and those plans did not come to fruition.
Were you able to make contact with the defense and have a subsequent interview with the defendant, Alec Murdaugh?
Yes, Mr. Apuli called me on September 13th, 2021, and we were able to set up a telephone interview of Mr. Murdaugh.
All right, I'm going to show you what's been marked as Exhibit 552, State's Exhibit 552, and see if you recognize this disc.
I do. This is a recording of the September 13th, 2021 interview with Mr. Murdaugh.
All right, this time I would offer State 552 into evidence, I believe, without additional objection.
No additional objections, Your Honor.
It's admitted.
I'm going to publish that to the jury.
No, it should not work. My telephone conference interview of Alec Murdaugh, 9/13/21.
What's that?
This is Jomar El Bayalden.
Was he present with you when you conducted this interview?
Yes, he was.
Jim.
Hey, Jim, this is Ryan Kelly and Jomar El Bayalden with SLED. How are you?
Hey, Brian and Joe.
Yes.
We had an office over here in Atlanta with Alec and Dick, and I'm just going to put the phone here on the table next to Alec. And I don't know if you guys. Well, let me start, Ryan. First of all, we only have about 30 to 40 minutes before we have to get out of here.
Okay, no problem, sir. Sorry about that. You caught me. I was halfway to Somerville, so I had to turn around and get into a place where.
And I'm sorry, but we were waiting here to see Alec, and once we got in here, we got to have a long discussion.
Okay.
It's official. I'd like to walk him through some questions, which will then allow you to question him, but give you some sort of, rather than just sort of wandering around.
Okay.
Okay.
Well, before we get started, can we just have, for the purpose of our notes, obviously we prefer not to do telephone interviews. This is how y'all requested, so obviously, we don't really have a choice. But we just I'm going to need Alex to identify himself, on the call, and basically what we do is I'm going to ask him his date of birth and the last four of his social.
Okay, go ahead.
Alex, just go.
Hello.
So you give me your full name.
Okay, Richard Alexander Murdaugh.
Okay, and what's your date of birth?
My date of birth is May 27th, 1968,
Last four of your social.
7483.
Okay. And I understand, obviously this is a unique situation conducting this interview over the phone. We need to, obviously you've been receiving some treatment. So just for the overall, sake of your competency to be giving us information, are you right now, sound body, sound mind?
Yes, sir.
Okay. Are you talking to us willingly?
Yes, sir.
Okay. All right, Dick, go ahead, sir.
Hey, just let me take the record. This attorney Griffin and Dick are doing it here. We spent the last hour talking to him. We believe that he is a sound mind and body, and that he understands, and that he has no way diminished capacity.
Okay.
He is perfectly competent to answer these questions. Now, we're willing to, we've advised you, we're going to talk about the shooting incident a week ago Saturday, where he was shot in the head, how that happened, who and why it was done.
Okay.
We don't want to talk about what happened in Moselle, and we don't want to talk about anything involving finances at the law firm. Is that okay?
Yes.
Okay. So, Alex, let's talk about last Saturday morning. And let me go through this briefly. Who did you meet with and talk to last Saturday morning?
I met with Jim Griffin and Chief Jesse.
And then what?
I met Anthony, and I met with Chris Wilson at my mom's house.
Okay. And you and Chris were talking about what?
About everything I had done.
Okay, everything you had done concerning finances.
Finances, bills, live.
Okay. Now, were you taking? Well, first of all, let me back up and say you had a long-standing OxyContin for opioid addiction issue.
Yes, sir.
How many years?
The best I can remember, around 20 years, 18 to 20 years.
Okay. Now, on this particular day, on this Saturday, were you taking the OxyContin or taking any opioids?
I had taken some, but I was taking. I given it all that I had someone else, and I'd taken some at like 4 a.m. So I was having some withdrawals.
Okay. And the previous day, the news had come out about your embezzling or taking client money, law firm money. Is that correct?
That's correct.
And how would you describe your state of mind at that time?
I was in a very bad place.
What does that mean?
I thought it would be better for me not to be here anymore.
What do you mean by not be here anymore?
I thought that it would make it easier on my family for me to be dead.
And easier Was some financial gain to your family if you were dead?
I have a fair amount of life insurance debt.
You remember how much?
Not off the top of my head, but like $10 million, $12 million.
Okay. And so you decided to end your life.
That's correct.
And tell these sweat agents how you went about arranging that.
I called Curtis Eddie Smith on the telephone.
Okay, now let's stop a second. Who is Curtis Eddie Smith?
Curtis Eddie Smith is the primary person who I purchased pills from for years.
And some weeks you would give him how much money for pills?
I mean, it'd be in my records, but we had weeks where there would be $40,000, $50,000, $60,000.
That you would give him for pills?
Yes, sir.
Okay, so you've known him for how long?
Years.
Years. So did you call him that morning?
Yes, sir, I did.
That day? About what time?
I'm not sure.
Okay.
But I asked him to.
Was it after you met with Jim Griffin?
It was after I met with Jim Griffin.
After you met with Chris Wilson?
I believe so.
Okay, and when you called him, what did you ask him?
I asked him to meet me.
Did he meet you?
He did.
Where did he meet you?
He met me out not too far from my mom's house.
Where?
He was on the side of the road. I think at the funeral home.
At the funeral home. Okay, and did y'all talk?
Not there. He followed me in town.
To where?
To over where I stopped by the Sunoco gas station.
Okay, did y'all have a discussion there?
Yes, sir.
Did y'all get out of your cars or just in your vehicle?
I don't think we got out of our cars.
And what vehicle were you in?
I was in my wife's Mercedes.
And what was he in?
He was in a gray pickup truck.
Okay, and what did y'all discuss?
I told him that things were getting ready to get really bad and that I would be better off not here. And I asked him to shoot me.
And you asked him to shoot you?
That's correct.
And what was his response?
I mean, I think at first he was a little surprised, but then he said, okay.
Did you tell him where you wanted him to shoot you?
Yes, sir.
Where'd you tell him you wanted him to shoot you?
In the head.
And did you tell him how you were going to arrange that? What was going to be the logistics of that?
Yes, sir.
Go ahead.
I told him to follow me out, and then I would make a flat tire, and he would go past me and turn around and come back and do it.
And did he follow you out?
He did.
Now, where did you get the gun?
I gave it to him.
Where did you give it to him?
We stopped somewhere on Salcatahatchee Road, I believe.
Did y'all have a discussion there, or did you just give him the gun?
We didn't have much discussion.
When you say much, was there any discussion?
I'm not sure. I was worried about the cars coming, and so it was a very fast thing.
You gave him, what kind of weapon did you give him?
A revolver pistol.
What caliber?
38.
Okay, and that was your gun?
Yes, sir.
Okay, and so he followed you out to where?
Salcatahatchee.
Okay, and you pull off the road?
Yes, sir.
And you pulled off the road, what did you do?
I stopped, made my tire flat.
How did you make your tire flat?
With a knife.
Whose knife?
Mine.
What did you do with the knife after you made your tire flat?
Threw it.
Which tire?
Back driver's side.
Back driver's side. You threw it where?
Across the road.
Across the road?
Yes, sir.
Okay. I mean, was it woods over there, a ditch, or do you know?
Just some grass, like thick grass.
Okay. And after you did that, he passed you? Or did he pass you as you were doing that?
I think that he had already passed me and was in front of me and went down the road, turned around and come back.
Now, when he was coming back, you gave him a pistol. What was your intent?
For him to kill me.
Okay. And when he came back, did he stop? Did he pull up, you know?
He did.
And when he pulled up, did you look in his face?
I don't think so.
So what happened next?
I stood close to his car.
And
he shot me.
Where did he shoot you?
He missed and hit me in the very back of the head.
Okay. And as a result of being hit in the back of the head, did that have any physical effect on you?
It did.
What happened?
I lost my vision for a little bit, and I'm not sure if it knocked me to the ground or not, but I was disoriented, and it took me like a minute and a half, 2 minutes for my sight to come back.
And did you remember him driving off? Did you hear him drive off? I don't.
I'm not sure.
Okay. Now, after you came to your senses, did your vision come back?
It came back.
Okay. And what's the first time you remember somebody else being there?
I remember there were two cars that came, and one of them did a stop, and one of them did stop.
And when it stopped, what did they do?
They tried to help me.
In what way?
In getting me to in every way that first we got in, they were crowded in their car. There was some reason why their car was crowded, and I'm not sure what that was. But so the young lady got in my car and was going to drive me to the hospital, and I just wasn't thinking about the flat tire. And so we had to get out of that, and then they worked it out somehow for me to be able to get in their car in the front passenger seat.
Okay, so and you got the front passenger seat. Where did they take you?
To meet the ambulance.
Now, did you call 911?
Yes, sir.
Did you tell somebody shot?
Yes, sir.
That's right.
At my request.
So your intent was to have him kill you so you could collect your life insurance, right?
So my son could. I mean, I knew I was about to lose everything, and I figured he's better off that way than dealing with me.
Now this gentleman that shot you, give me his name again.
Curtis Eddie Smith.
What kind of vehicle was he driving?
Gray truck.
Okay, and it's probably not relevant, but I'm intrigued by the fact, how long was it, have you ever discussed with him before killing you? Oh, you committed suicide?
No, sir.
How long did it transpire between the time you asked him to shoot you in the head on the side of the road and he actually shot you in the head on the side of the road?
And when I first asked him, we were at the Sunoco station in Barnville.
How long after that did he actually shoot you in the head?
However long it takes to drive from there to Talkahassie Road.
More than half an hour?
I don't think so.
Did he ever ask you to reconsider or say, no, things aren't that bad? Did he ever, try to convince you to do otherwise?
No, sir.
You find that strange?
I didn't. I was focused on
what?
Being cold.
So that's all the questions I have, but I tried to lay it out as expeditiously as possible, but he'll be happy to answer any other questions. Any additional questions, again, I know.
Okay.
The interviewer, so y'all have that. We've got about another 20 minutes.
Okay, thank you, sir.
Hey, let me ask you this, y'all recording this, aren't you?
Yes, sir, we are.
Okay, good.
Yeah. So Alex, how long have you known Curtis Smith?
And Ryan, Officer Kelly, before we start, I just want to tell you, I apologize to you for lying to you in the hospital. I was in a very bad place.
No, so we understand, and I do appreciate you, helping us figure this out now. So that's in the past, so let's just focus on what we're doing now. How long have you known Curtis?
I've known him for years. I represented him. He knew my dad somehow from playing softball, and he came to my dad with a lawsuit, and I handled that case. So I would guess 10, 12
Okay.
years ago.
How often would y'all talk on the phone?
Very frequently.
Okay. And what would y'all talk about?
Getting pills.
Okay. And you would pay him money to get you bills, correct?
Yes, sir.
Okay. How often would you pay him?
Frequently.
Okay. Well, I mean, once a week, twice a week?
It would vary sometimes, but it was several times a week.
How would you pay him?
In cash, and mostly in checks, but in some cash too.
Okay. And what accounts would those checks come from?
The vast majority of them would come from the Bank of America account, but there would also be some funds that would come from the Palmetto State account.
Whose accounts are those?
Mine. The Bank of America accounts are in my name, and then there's another account there that I created that's a DBA. That's my name, DBA Forge, and then my checking account at Palmetto State Bank.
Okay, so there's two accounts at Bank of America?
Yes, sir.
The DBA and then your checking?
Yes, sir.
Okay. And what is the DBA?
Forge. F-O-R-G-E.
Thank you. Okay, and then the Palmetto is your was the other checking account?
Yes, sir.
Okay, and who was he? So you were paying him the money. Do you know who he was getting the drugs from?
No, sir.
No. What do you tell you where he's getting?
Oh, well, I was told that he got him from a black guy in Walterboro, and I was told that he had some connection in Beaufort, but I never.
They give you a name?
No, sir. I never saw those guys. I never dealt with those guys, so I don't know. That's what he told me.
Would you ever give anybody else money for drugs?
Yes, sir.
Who else did you give money?
I had given Kenny Hughes money.
Who's Kenny Hughes?
He's a guy that I called up and asked him if he knew anybody that he could buy pills from.
Mm-hmm.
And I told him I had a client that had issues and couldn't get them medically, and that, and I would pay him as well, but I called him up and asked him to do it.
All right, how much money do you think you gave him?
I have no idea.
Okay, did you write him a check or pay him cash?
Both?
Okay. Did you pay anybody else?
No, sir.
So it was just Curtis Smith and Kenny Hughes?
Yes, sir.
Sure about that? Think about it.
In the past, I have paid other people.
Okay, who are those other people?
I had a lady that worked at our house that, at our mom's house that.
And who's that?
Barbara Mixon. But that was on very, very few occasions.
And did you pay her a cash and check, or how'd you pay her?
I'm not sure.
Okay.
That was on very limited occasions.
Okay. Is there anybody else?
Not that I can think of right now.
Okay. So the .38 revolver, it was your revolver?
Yes, sir.
Okay. Where did you get that from?
It was at my mom's house.
When did you pick it up?
When I went up there that day.
Do you know where it is now?
No, sir.
So you gave the gun to Curtis, and you don't know what he did with it?
That's correct.
Has anybody in your family had any communications with Curtis recently?
I don't know why.
Well, because when we interviewed him, he said he had to talk to his attorney first, and he listed you. And then when we said that wasn't possible, he listed Randy. So we're just trying to figure out.
Randy's not going to represent him.
And let me say this to maybe.
Well, I got one more question. Does Randy have any knowledge of this?
Does Randy have any knowledge of what?
Of this attempted suicide / agreement with Curtis?
I have told I told both my brothers and my son very recently.
Yesterday.
When was it yesterday?
Yesterday. After we told him we're coming here so that he could tell you, he wanted them to hear from him first.
Okay, so Randy didn't have any knowledge last week previously?
No.
Absolutely not. I lied to him too.
Ellen told me yesterday about 4:15, and then I sort of kept John Marvin off, and then later on I learned that, and I talked to Alec, and he had called Buster, John Marvin, and Randy after I spoke with him at 4 o'clock yesterday afternoon. We didn't about to do that. We're trying to.
And before that, I told them the same lies that I told you.
Now, here's an important thing. Since the shooting, have you talked to the shooter?
Yeah.
Okay, tell them about those calls.
I'm not sure. I was in the very beginnings of my detox, and I could just see where I tried to call on the phone. And I know I talked to him, but I don't have it.
You called him or he called you?
I called him.
Okay, but you don't remember what he said.
I don't.
Do you remember you told him?
No, sir.
And this is when you were in the hospital in Savannah?
No, this is when I was in detox here.
Okay, so you called him since because you went to detox.
Yes, has the investigation revealed, as you testified before, that the defendant, like Murdaugh, did call Eddie Smith, trying to use staff phones as well while he was at the hospital additionally in Savannah?
Yes, Mr. Murdaugh was able to contact Mr. Smith while staying at the hospital in Savannah. When? Monday night?
That's right.
Did you call him on a nurse's phone from the hospital? I've heard that from.
But you know what? Randy did say I did that.
But you don't have a memory.
Randy said that I called him, and then he was asking me. He did say I did that.
Oh. But you don't remember calling Curtis?
I don't, but I'll tell you from past experience that when withdrawals begin, you will do just about anything to make them quit. And I probably was calling them for that purpose. Probably.
All right, so you don't know where the gun is at?
No, sir.
But you last saw it in Curtis Smith's possession?
I gave it to him, yes, sir.
All right, so the accounts that you were writing the checks to Curtis were Bank of America and Palmetto State Bank?
Yes, sir.
All right, and the funds, where were those funds coming from?
Well, that's maybe an area we don't want to talk about, but just let's say the bulk of them were not legitimately obtained.
Okay, and I'm not trying to be coy. It's just that, Mr. Murdaugh is independently wealthy, so.
Not anymore.
Well, I understand that, but, I think it's a pertinent question. So
look, he was independently wealthy, but there's a significant amount of money missing from clients in the law firm.
Okay. So the money came from ill-gotten gains? Is that what?
Some of it, most, I would say the majority of it, but some of it, I'm sure I use my own personal funds too.
Okay.
I mean, I was buying so many.
All right, so just let me get this straight. So you entered into did you pay Curtis any money for this?
No, sir.
You didn't pay him anything, so you just asked of a favor and he did it?
Yes, sir.
Sure, that's great.
And so, and these checks that you were paying to Curtis, I mean, they were pretty significant, right?
Yes, sir.
And when was the last time, I'm not trying to get you to it. When was the last time you made a payment to Curtis? Was it before the shooting?
It would have been, not like right before the shooting, but it would have been several days.
Okay. Did you remember how much you paid him?
No, sir. I think the last few times I paid him were all in check, and I was trying to, see him as little as possible.
All right, now let me ask you this. Do you owe money to any drug dealers?
No, sir.
So there's not a threat out there that we need to worry about for Buster?
No, sir. No, sir.
Okay, so the money that you were paying to Curtis to get money from his dealer or his supplier, you were paid in full in those payments. So there's no outstanding debt that we need to worry about.
No, sir.
And Ryan, that's assuming that Curtis passed all the money along.
Well, no, I understand. And so to the best of your knowledge, you don't owe anybody.
No, sir.
Okay. So the money that you paid him, you don't remember how much you paid him, but it's for pills. And you're saying that you didn't pay him at all for him to shoot you.
That's correct.
Now, I'm gonna be honest, that doesn't make any sense to me.
I understand.
And I know that, like, whether you did or you didn't, it really doesn't have that much of a difference. So I'm not gonna, but I appreciate you're being forthcoming and you're making every attempt to be honest at this point. But so, I just want to make sure that we're all on the same page. So you did not make any financial payment to Curtis to have him shoot you.
No, I did not.
Okay, but you entered into a verbal agreement with him to set up a scheme where he would shoot you. It would be a suicide set up as a robbery homicide. And you doing so was in order for your son to get your life insurance policy.
I don't know about a robbery, but everything else is straight.
So let me say this: he's had this policy for 10 years. Suicide.
I've had a policy.
No, I understand it. Policies. I mean, what is the policy with? Where's it at?
I don't know where the actual policy is.
Okay. Did you intend to have that paperwork in the Mercedes, like the will and all that information? Was that left in there intentionally?
Well, I've been down to meet with some lawyers about some things, and it was in there from that day for I can't call her name now. My Buster's girlfriend's employers, Kathy Olivetti.
Yeah. And you meet with them about why you have wills.
Just get things cleaned up. I've been down in that one time before, and
Ryan, there's a 2-year statutory ban on any suicide exclusion. In other words, if you got a policy for 2 years, you can commit suicide and still collect.
Yeah. Okay.
So that's not, now, what he thought really doesn't matter, but he may have thought.
Yeah.
Within a problem.
Okay. But you still entered into an agreement basically to have him kill you, so your son would then reap the insurance benefits. And
Yeah.
Okay.
Okay. Is that true?
yes, sir.
All right. So how did you get the knife? Was it your knife?
I think that Eddie gave it to me. Chris Eddie Smith gave it to me.
Okay. And then how did you make the tire flat?
I just stuck it.
So you punctured the tire with a knife?
Yes, sir.
Okay. So Eddie gave you the knife. You took the knife and punctured the tire.
Correct.
And then what did you do with the knife?
Threw it.
Threw it where?
I believe across the road, but I'm not absolutely positive.
Okay. You threw it. You disposed of it in the area of where the Mercedes was parked?
I think I threw it across the road from where it was parked.
Okay. Okay. Do you know if they disposed of the gun out there?
I do not know.
Okay. Okay. Was that gun registered to anybody?
Probably. Should have been. I believe that I purchased it, so I believe it would be registered to me.
You remember when you purchased it?
No, sir.
Where would you purchase it?
Yeah, I got no idea.
You have Thursday's phone number?
Sir?
You have Thursday's phone number?
If y'all have them, we'd love to get them.
Yeah. It will come out. Yeah, the phone number 843-908-1534. And a phone number 843-538-4691.
Right. Alex, did you ever have any dealings with anybody else besides Eddie? Any of his friends, family, girlfriend?
I mean, I knew who his girlfriend was, but I never had any dealings with her about this.
Who's his girlfriend?
A lady named Donna Eason. I don't know her very well, but I've just helped her with a couple of little legal issues over the years.
Okay.
But she never was involved in the exchange of pills or money.
Okay. Is there a property up in Hugie?
A property where?
In Hugie, up 41. Do you guys own any property up there?
Oh, yes, sir. And outside of Charleston?
Yes.
Yes, sir.
Tell me about that.
There's a piece of property that I own with a bunch of other people that nobody else would pay. And so I've been paying for it. And he did some work up there, digging some ditches.
Right. When did he do that?
He started within the last couple of months.
And that property, where's it at in Hugie?
It's also on United Road, United Drive.
Okay.
I think it's called Redbeard and 0 United Drive.
We're going to have to jump here in just a minute.
Okay.
Down here in just a minute.
All right. Alex, is there anything else that we're missing? We're not asking you.
Like, in regards to what? Nothing I can think of, but like, what are you thinking?
I was kind of leaving that open-ended. Like I said, I'm not trying to get, I'm not involved in the other aspects of whatever other investigations. We're keeping those separate. So you communicated with Curtis. You would communicate with him over cell phone?
Yeah.
Okay. How many phones do you have, Alex?
I had one phone. 1227 was my primary phone. And then,
I have to download that phone, right? When SLED started focusing on Alex as a target, we started doing our own work. So I took possession of that and sent it to a guy to download, and he had to get a separate phone, and that was that other number. And then y'all see both of those. That's my understanding.
All right. Then he's got a third phone that he got prior to going to the treatment center.
Yeah, from Walmart, from Vertical.
Okay. What is his extended? What's your expected length of treatment there in Alpharetta?
Well, it's unclear right now, but it'll go from here to rehab at some point. But we'll keep you posted.
Okay. So anytime you're, obviously so you've identified Curtis Smith as the individual who shot you, and y'all entered into an agreement. So y'all kind of were hand in hand in this.
Very much so.
And he never tried to talk you out of it?
I don't know. No, sir. I don't think he did.
Okay. Did anybody know about this plan besides you and Curtis?
No.
Okay. All right.
If y'all have done this already, now, if you tell us the truth, I just want to make sure Ryan understands, given we him on a very,
No, I did not tell anybody the truth until, was it yesterday? Until yesterday afternoon.
Okay.
I've been really, really sick, and it's really the first day where I had any coherent thought process. And I sincerely apologize again for lying to y'all about everything that I did.
Yes, sir. And you have no idea where the gun is?
I do not.
Now, you're right-handed, right?
I'm right-handed.
Okay. You did not shoot yourself, correct?
I did not shoot myself.
Did you? And what was the plan for Curtis to follow you out there, and you would immobilize your vehicle? So did he stop to make it fly? For you to give you the knife first? I mean, how did that play? Because you got the knife from Curtis. When did you get the knife from? When did you get the knife from him?
I think I got it from him when I gave him the gun.
Okay, over in when you were at the Sunoco.
No, we didn't do it then. That's when.
Okay, when you pulled off the side of the road in Salcahatchee.
Shortly after we made the turn onto Salcahatchee,
Mhm.
we stopped and did a quick exchange.
Okay, so you stopped, pulled over the side of the road, stuck the tire. Where was Curtis at when you were disabling the tire?
I believe he was going past me.
Okay, so you turned around, and where were you at when you turned around?
I'm not sure. I mean, I was on the side of the road, I think.
Okay, so did you pull up, kind of like what you said, just past your car?
That's basically the way I told you it happened is kind of how it happened, except it was arranged by me.
Okay, so as you turned around and turned your back to him, about how far do you think you were from the car?
I don't know, 4 or 5 feet.
Okay, 4 or 5 feet. And did you just stand there and wait for him to shoot you?
Yes, sir.
Okay. And I'm assuming he just fired once?
Yes, sir.
And then you fell to the ground or stumbled off?
I'm still not positive about that part, but I did lose my vision for about a minute and a half to 2 minutes.
Okay. And why weren't you truthful with us when this initially happened?
I don't have a good reason. I was in bad place.
Okay. All right, gentlemen. Well, I know our time's cut short, but
Ryan, I'll call you from the car once we get out of here in
Okay.
in just a couple minutes, and then I'll call you while we're driving back to the airport.
Okay. Yes, sir.
Okay.
All right, gentlemen. So we'll finish this. We are finishing the recording with Richard Alec Murdaugh, his attorney Tiff Harpulian, and Jim Griffith, and Special Agent Brian Kelly. Special Agent Delmar All Day. It is now 4:58 on Monday, September 13th. Thank you, all, gentlemen.
Thank you.
Thank you, sir.
Special Agent Kelly, is that a complete conversation that you had with Alec Murdaugh on September 13th, 2021?
Yes, it is.
Prior to that conversation, over the course of the 911 call, the ambulance, and multiple interviews at the hospital, did Alec Murdaugh ever mention or identify Curtis Edward Smith at all until his lies about the side of the road were exposed?
No.
Did Alec Murdaugh ever say that there was any risk or threat to Buster?
He said no. No, he did not. He actually denied it when we asked.
Did Alec Murdaugh say that Curtis Edward Smith had anything to do with the murders of Moselle?
He denied it when we asked.
And is there any evidence that Curtis Edward Smith had anything to do with Moselle?
None whatsoever.
Thank you. Nothing further.
Mr. Harpulian?
Your Honor, I understand we have a 4:30 cutoff. You just want me to go as far as I can go?
Or we can adjourn now for the day.
I don't, this is going to take a while, and I would suggest perhaps maybe one adjourn.
Ladies and gentlemen, we are going to adjourn until 9:30 tomorrow morning. Is that order? I'm speaking to the jury. We're going to adjourn until 9:30 tomorrow morning. Have a good evening. Please do not discuss the case. Please do not discuss your testimony with anyone overnight. You'll be cross-examined tomorrow morning. And we will be in recess.
All right.
Good morning. It's been a long trial, hasn't it? On June 7th, 2021, at the Moselle property in Colleton County, Meg Murdaugh and Paul Murdaugh were brutally and maliciously murdered at the kennels by Alec Murdaugh. Paul, as you know, suffered 2 shotgun blasts. Maggie suffered 5 blackout rifle wounds. And after an exhaustive investigation, there was only one person who had the motive, who had the means, who had the opportunity to commit these crimes, and also whose guilty conduct after these crimes betrays him. The defendant is the one person who was living a lie. The defendant is the person on which a storm was descending. And the defendant is a person where his own storm would actually mean consequences for Maggie and Paul, and consequences for those who trusted him. And that person is the defendant, Richard Alexander Murdaugh. I know this has been a long trial because it's a complicated case. And I'm not going to talk forever, I promise. But I am going to try to distill this down for you. And the first thing I want to do is set the stage. And to set the stage, we have to understand a little bit about Alec Murdaugh and who he was and who he is. He was a person of singular prominence and respect in this community. But he's also a person who's been able to avoid accountability for all of his life. While he was outwardly giving the illusion of wealth and a very lucrative law practice, some bad land deals and that sort of thing, exacerbated by the economic recession, led to some financial problems. And then he had some big cases in the early 2011, 2012. And all his partners, you've heard testimony to this, thought that that had taken care of things. You've heard cases like the Thomas case and the Pinckney case and the Plower case and the Badger case. But the evidence that you've heard shows that the defendant became so addicted and so dependent on a velocity of money that millions of dollars in legal fees that he was receiving was not enough. And so he started to steal. And how did he steal? He stole by billing personal expenses to the firm. He stole by stealing from his own family. You heard the testimony about the check he stole from his brother Randy. But then the main ways were 2 schemes that he developed. And the first one was to get checks made out from the client trust account to Palmetto State Bank, to fast talk the staff and fast talk the clients with those disbursements, and then take it to Palmetto State Bank, where his buddy Russell Lafitte would convert those and use those to pay personal expenses. And each time, until the end, it worked because the client was also getting a big check. And they were walking out of there thinking that everything had been fine when it was not. But then in 2015, he opened up the fake Forge account. And then all he had to do was get disbursements paid out to the Forge account. And once he did that, he would convert those to his personal use. And to do that, though, he also had to fast talk staff and fast talk clients. And that scheme continued up until everything fell apart in the end. The other thing you have to understand is during this time, when he's earning millions of dollars and stealing millions of dollars, he's also borrowing millions of dollars from wherever he can. The bank, his law partners, his father, and it still wasn't enough. And this slow burn was continuing and continuing until the boat crash happened in February of 2019. And that changed everything. That set in motion things that were going to happen because of the criminal charges related to that case, as well as the civil charges related to that case. And in the aftermath of the boat case, things changed. The pace of his stealing increased. In fact, that's when he stole the money from Tony Satterfield that you heard from. Ultimately stole about $4.5 million between the Satterfields and others. And unlike other cases, Tony Satterfield, who was the son of his longtime housekeeper, he took all the money, took every bit of it. And that was coming to a head as we move into the spring of 2021, because there had been some publicity, and you heard from Tony Satterfield that he was the defendant reached out in the spring of 2021 because there had been publicity and saying, hey, I'm still working on the case, everything's fine, I'm still working on the case, it's good. But the reality is the defendant didn't have that money to pay it back. And he had one saving grace, because as you've heard, they don't get paid until the end of the year. And his saving grace was the Ferris case, which they tried in December. They get the verdict and get paid in March, and that's when he convinces Chris Wilson to send those $792,000 of fees to him. But the problem is that only lasted for about 2 months. $792,000 only lasted for about 2 months. And then he's running out of money again. Meanwhile, you've heard in the boat case that Mark Tinsley was seeking to get a large personal recovery from Alec Murdaugh of $10 million because he thought, as many people did, that he was wealthy and had a lot of money. And when they said he didn't, he filed a motion to compel. And you've heard testimony about whether or not that had been granted, but it doesn't change the fact that that's what Mark Tinsley was seeking to do. And that boat case hearing had been scheduled for June 10th. In May of 2021, as we move into June, that's when Alec's own paralegal got the expense check for the Ferris case, but not the fee check, and tried to raise that to Alec and couldn't get a straight answer, tried to raise it to Chris Wilson and couldn't get a straight answer to his office. And so it goes to Gene Seconder, and Gene Seconder goes to the partners, and they can't get an answer about that either. And they want an answer to that because they're worried, because Alec has been talking about structuring fees, and they're worried he may be trying to hide assets because of the boat case, and they don't want to be a part of that. All of these things are coming to a head, and his finances are falling apart. And you heard from the banker there. You heard where his finances were at on June 7th, 2021. And you saw what happened in the wake of that. Within a short period of time, he was negative $347,000. On June 7th, 2021, he was in the office. He was working on the boat case, working on those financial disclosures, when Gene Seconder came in and confronted him about those fees that he no longer had and couldn't pay back. And on June 7th, 2021, and he tells this to Gene Seconder, his father Randolph is having a very difficult time. And while they might have said it was some positive news, the reality is that he was very, very sick. And he'd always been someone that the defendant could go to, that he could borrow money from. And so that pressure is happening as well. And on June 7th, 2021, as all these pressures were mounting, the defendant killed Maggie and Paul. And how do we know that? We're going to talk in detail about that. But the timeline puts him there. The forensic timeline puts him there. The use of his family weapons corroborates that. And his lies and guilty actions afterwards confirms it. And we'll go over each of those in great detail. Before we get to that, though, I want to finish out, because in the wake of this, everything changes. All those things that were coming to a head immediately go away. It's a different world now. They're not asking about the Ferris fees anymore. And you heard testimony to that. Mark Tinsley doesn't believe the case is going to have the same value anymore because the sympathies of the case have changed after this tragedy. And you heard that. Who would better understand that than Alec Murdaugh, who does the same work? The boat case hearing goes away, and everyone immediately rallies around Alec Murdaugh. And it worked, because it allowed him to borrow $250,000 from Johnny Parker, his law partner, who of course wouldn't have loaned that money if he knew what Alec was up to, and allowed him to go to Colorado State Bank and get $350,000 in an off-the-books loan that hadn't even been applied for, and to send that money to Chris Wilson and convince Chris Wilson to pay another $192,000 of his own money, and to send an email to the firm that everything was okay. And that made it another month or so until Annette Griswold found that Ferris check in his office, and Jeannie Seconder looked up the 40 counts. What happened in the wake of that? What was the reaction of Alec Murdaugh? Within a day, September 3rd, of him being forced to resign, his buddy Chris Wilson is trying to see him, comes and sees him on September 4th, and confronts him about what he's been doing. And then within 2 hours, the side of the road happens. And Alec is a victim again. When accountability was at his door, he was a victim again. And he told an extremely detailed lie and went so far as to draw a composite sketch with the police of this assailant. And the accountability that had arrived at his doorstep again, he tried to get it to go away, and it worked for a little while. People thought, oh my gosh, what's happened here? Should we be suspicious of Alec anymore? But this time it fell apart a little quicker, because his own brother figured out that he was trying to buy drugs. And the case fell apart very quickly. This is the setup for what we look at and what's going on. And it seems like a story that's far removed from most people's experience, because it is. It is a different story like has never been seen before. But the reason is that he is a different man than the kind of stories that we've seen before. This is a different set of circumstances than we've seen before. And it's certainly easy to understand when you have a middle-aged man who's outwardly successful, who has a strong family legacy, who has a prominence in the community and a reputation, but is living a lie. Is living a lie. And that leads to, and can lead to, those pressures being overwhelming and actions like this happening. Husbands have been killing wives, unfortunately, for years, and husbands killing sons goes back as far as King Herod, probably further. And those pressures mount, and someone becomes a family annihilator. Have the computer input, please. All right. Got to do a little law school. I'm certainly not a professor, but we need to go through a few of the concepts here. And one of the most important concepts is the fundamental role. One of the fundamental roles while y'all are here. As the judge has told you, he's the judge of the law, but y'all are the judge of the facts. And what does judge of the facts mean? Well, a big part of that is that you determine credibility. You determine believability. You determine which witnesses you want to rely on or not rely on. You can rely on a part of a witness's testimony, all the witnesses' testimony, one against many, many against one. It's up to each one of you individually to make that determinations and decisions, and then to collectively discuss those into a group decision. But credibility is important. Is it believable? Is what somebody's telling you believable? And there's many things you can consider in credibility, but a few of those are the demeanor of the witness on the witness stand, whether the witness has a reason to be biased, whether the testimony of the witness was contradicted on one hand or supported or corroborated on another, whether the witness has been dishonest in the past. And again, you can believe witnesses all against one against others, and you can believe portions of the witness's testimony as you see fit. Same thing goes for experts. Expert is a legal determination that allows them to give an opinion. Just because someone's qualified as an expert doesn't mean that you have to accept their opinion. You can judge that based on your assessment of the credibility and the relevance and the believability of that testimony. There's nothing different about that when someone's an expert. Beyond a reasonable doubt, I talked about this at the beginning of the case, and it's our burden. It's a burden we welcome. It's how this system works, that we have to prove the guilt beyond a reasonable doubt. And what is a reasonable doubt? A reasonable doubt is a doubt that makes a reasonable, honest, sincere juror hesitate to act. It's proof that a reasonable person would not hesitate to rely on in their affairs. But a reasonable doubt is not, and leaves you firmly convinced of the guilt of the defendant, but it doesn't have to overcome every possible doubt. It doesn't have to overcome every possible doubt. I used to try a case against a defense attorney and he would pull up a picture of something. Right here, I have the Mona Lisa. And he would tear off a piece like that and say, ladies and gentlemen, that's reasonable doubt. And my response to that is, you still know what this is, right? You still know what it is. And that's reasonable doubt, okay? If you still know what it is and you're firmly convinced, then it's your duty under the oath that you've taken, as the judge will give you the law, to convict the defendant. Direct and circumstantial. Directly proves the existence of the fact, and circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of that fact. And we talked a little bit about that at the beginning. Sometimes people in common discussions will say, oh, the case is just circumstantial. But the law says it doesn't matter. The circumstantial evidence can be just as good as direct evidence. It is just as good. It makes no distinction between that, and the judge will charge you on that. There's no greater degree of certainty required of circumstantial evidence than of direct evidence. The circumstances must be consistent with each other and taken together point conclusively to the guilt of the defendant. And I gave you all an illustration at the beginning. I'm not going to redo the whole thing, but about being inside. And you go outside and it starts raining, then you know it's raining, okay? Because you got direct evidence, you're getting wet. But if you go inside and you're in a closed room, and all of a sudden it gets dark and you hear thunder and you hear the wind rustling and you hear the rain coming down on top of the roof, and then after an hour or so you go outside and the sun's shining, but there's limbs all down in the yard and it's wet as far as the eye can see, and there are puddles in the yard and puddles in the driveway, is there any reasonable doubt what happened? Did it rain? Now, again, I'll say it again. Supposedly, I guess somebody could have sprayed the whole neighborhood with a hose and blown a fan to blow the wind down, or blow the limbs down. It seemed like wind, but that's not a reasonable doubt, ladies and gentlemen. Circumstantial evidence can be just as strong as direct evidence. It is just as strong. The law makes no distinction just because it's circumstantial. All right, let's talk about murder. Murder is the willful killing of someone with malice aforethought. It's the unlawful and willful killing of any person by one with malice aforethought. The crime of murder is really, as far as the elements go, fairly simple. The operative terms here, the most important terms are malice, which is the mental state that the person must have, and aforethought. But let's talk about those. What exactly do they mean? Malice, and it can be any of these. It can be the hatred, ill will, or hostility towards another, but it also can be the intentional doing of a wrongful act with an intent to inflict an injury under the circumstances that the law would infer an evil intent. It can be a general malignant recklessness of the lives and safety of others. It can be a wicked or depraved spirit intent on doing wrong. It could be using firearms, shotgun in a blackout to blow somebody away. That could be malice, ladies and gentlemen, if that's what you decide. A forethought sounds like it has to be planned, and certainly planning would account for a forethought, but it may be conceived at the very moment, a split second, or in conjunction with the act. So a forethought doesn't require planning for that malice to occur. All it has to do is exist in the moment, just a split second, or in the moment that the act occurs. So when that trigger is pulled, as long as there's that intentional doing of a wrongful act, intent to inflict an injury, there will be an evil intent, a malignant recklessness, which you can infer from the circumstances of the case, and that's all you need. And how do you do that? I said infer, because people don't always yell out what their intentions are. You have to infer it from the circumstances of the case itself. Look at the crime scene, look at what happened, look at the backstory, look at all the circumstances that come together, and you can infer malice from those. Last little bit of law school. Malice and drugs. Voluntary intoxication does not impair a person's ability to act with malice aforethought. That's a legal principle. If you voluntarily get intoxicated, it is not a defense to a crime, and it does not negate the malicious nature of that crime. If one voluntarily intoxicates themselves, they are just as responsible for their actions as when they are not intoxicated. And the judge, again, take what the law comes from the judge, but this is a legal principle that you will hear. Voluntary intoxication is not a defense to a crime. And why does the law say that? Well, you can't take whatever it is and deny responsibility for what you've done under the law. All right? I'll move through this quickly because we've already talked about it. And just for scheduling, I'm going to have to stop my argument so that we can all eat. But I'll give you all a chance to get away from this for a little bit. But I'm going to go ahead and go through some of this that we just talked about, but very quickly. Gathering storm in Alex's life. We talked about the family legacy. You heard how important that was to him and how important that was to his family and how it was in danger because of the boat case. The criminal charges as well as the civil charges. That legacy was in danger. And it was threatening also to expose him for who he really was, which would totally destroy his part of that legacy. Lose his career, lose his bar license, face consequences like he's never seen. He's also a successful lawyer and a part-time prosecutor. And as we go through and talk about the circumstances of this case and talk about the crime scene and the timeline and all the rest of it, think of it with that in mind. That this is an individual who is trained to understand how to put together cases, complex cases. He's been a prosecutor. He's done complex car wrecks. He understands the law. He's given closing arguments to juries before. So when you have a defendant like that, be thinking about whether or not this individual is constructing defenses and constructing alibis.